hearing of the Senate Finance, Administration, Legislation Committee's inquiry into the Workplace Gender Equality Amendment Setting Gender Equality Targets Bill of 2024. Today we begin by acknowledging the traditional owners of the land on which we meet and pay our respects to elders past and present. On behalf of the committee, I welcome everyone here today. This is a public hearing and a Hansard transcript of proceedings is being made. The hearing is also being broadcast via Australian Parliament House website. Before we start taking evidence, I remind witnesses that in giving evidence to the committee, they're protected by parliamentary privilege and that it is unlawful to threaten or disadvantage a witness on account of evidence given to a committee. Such action may be treated by the Senate as a contempt, and it is also a contempt to give misleading or false evidence to the committee. We generally prefer for evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in private session. If witnesses object to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground on which is claimed. If the committee determines to insist on an answer, a witness may request that an answer be given in camera. Such a request may, of course, also be made at any other time. I would also ask witnesses to remain behind for a few minutes at the conclusion of their evidence in case the Secretariat needs to clarify terms or references, and I remind people in the hearing room to ensure that mobile phones are switched to silence. This morning we now welcome representatives of the Australian Council of Trade Unions, the Health Services Union and the Financial Services Union. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. So for commencement, I now ask witnesses online to please state your full name and capacity in which you appear today. Over to you, our witnesses online.
Good morning, Chair and Senators. This is Sasha Peltover-McClelland, and I'm here on behalf of the ACTU. I'm a Senior Legal and Industrial Officer.
Thank you.
Good morning, Senators. My name's Julia Angrisano. I'm the National Secretary at the Finance Sector Union.
Thank you.
And Kate Marshall, Senior National Assistant Secretary at the Health Services Union. And I must apologise, my camera has decided not to play nice today, and I can't get it to work, so I'm so sorry.
We can hear you clearly, Ms Marshall, so that shouldn't be a problem. I now invite you to make short opening statements, and at the conclusion of remarks, I'll invite members of the committee to ask questions. Great, thank you. We'll start with the ACTU. Thank you.
Thank you, Chair and Senators. I'd like to acknowledge that I'm speaking to you today from the land of the Wurundjeri people of the Kulin Nation, and I'd like to thank the committee for the opportunity to make a submission and to appear today. The ACTU welcomes and fully supports this bill, which implements an important recommendation of the WGEA review to bridge the action gap by requiring employers with 500 or more employees, referred to as DREs, to set and make progress towards gender equality targets over a 3-year cycle. Unions have been calling for this important reform for many years. We know from our affiliates that there's often a significant disconnect between an employer's stated commitment to gender equality and actual tangible actions and outcomes. This is part of the reason the gender pay gap and gender inequality persist. WGEA data shows that 42% of DREs are not making progress on closing the gender pay gaps. And the research tells us that target setting is an effective tool to advance gender equality within organisations because it requires employers to pay attention to the issue. It acts as a prompt for action, it creates accountability, and it embeds systemic cultural change. If passed, this bill will build on the significant progress that's been made towards closing the gender pay gap over the last 2 years by the Labor government, which has seen it close at 3 times the rate achieved under the former coalition government. It's dropped from 14.1% to 11.5% over the last 2 years. The ACTU makes 9 recommendations in its submission that will strengthen the bill and accelerate progress towards closing the gender pay gap and achieving gender equality. And I wish to quickly emphasise 5 improvements we consider the most crucial. Firstly, the obligation to set targets should be extended to employers who have 100 or more employees. The 500 threshold is too high, as it leaves out nearly 3 in 4 employees, or 73% of the labour force. Given that employers with 100 or more employees already need to report publicly to AGIA each year on their gender pay gaps, and the vast majority already have policies and strategies in place, in addition to the strong business case we know exists for gender equality, the threshold should be lowered to 100, and that would cover an additional 3 million employees, or closer to 1 in 2. Secondly, all DREs should be required to make progress towards closing the gender pay gap, as well as picking 3 other gender equality targets. This would ensure employers can't simply pick the easiest targets and avoid making meaningful progress. The gender pay gap is the clearest single indicator of progress towards gender equality that we have, and all other indicators and targets will contribute towards it. Thirdly, the compliance regime should be strengthened. Procurement alone is an inadequate incentive. It's unclear to us how many DREs are actually involved in Commonwealth procurement and to what extent, and clearly it won't be a meaningful incentive for those who do not have involvement in that space. We recommend that non-compliant employers should also be barred from being eligible to receive Commonwealth Government grants, and that there should also be civil penalties for non-compliance. Without adequate enforcement, there's a significant risk that there will be many employers who simply don't comply, as we have seen with the modern slavery legislation. Fourth, the bill should ensure there is meaningful consultation with unions and delegates. The evidence shows this achieves better outcomes on pay and conditions, health and safety, productivity and satisfaction. Despite the recognition now given to workplace delegates under the Fair Work Act, there's no role for them or for unions in the bill, and this risks undermining their representative role. Employers should be required to consult unions and delegates on the gender equality targets they select and on the plans to achieve them. And they should also agree workplace consultation measures with delegates and their unions as a first step to ensure that consultation is genuine, effective, and has the capacity to influence decisions, rather than simply being a tick-the-box exercise. Unions have been instrumental in working to improve gender equality in workplaces for decades, and there are countless examples of this that I don't have time to go into. Workers and their unions are in a unique position to know what measures would practically assist in tackling gender inequity at work, and workplace cultures simply won't become more equitable unless workers and their unions are genuinely and regularly consulted on and involved. Finally, the gender equality targets themselves must be strong and effective. There is a risk that employers might set their own numeric targets so low that they won't be meaningful. Further, some of the targets as currently drafted replicate existing legal obligations of employers. This reform should ensure that targets are significant and meaningful, that they don't replicate existing obligations but require something additional, and that they are regularly updated and improved in consultation with unions and others. And in order to ensure these things, it's appropriate that the targets are contained in regulations rather than in the bill. Thank you.
Ms. Angrisano.
Thank you, Senator, and thank you to the committee for the opportunity to provide the finance sector union's perspective on the Workplace Gender Equality Amendment Bill. And I also want to acknowledge that I'm speaking to you from Gadigal country. We welcome the changes in the bill, and we're keen to see the quick passage of this legislation through Parliament. The data collected by the agency plays a critical role in the work of the union, and the recent changes that provide transparency in employer pay gaps have been so effective that we have seen the first significant annual drop in the total remuneration gender pay gap in the finance industry since we started keeping records. The drop of 4% in the last 12 months compares to a drop of just 4.6% in the previous 5 years of reporting. We think it's a remarkable demonstration of the impact of transparency. And while we believe that introducing requirements for employers to set gender equity targets should further improve gender equity in the workplace, the effectiveness of these measures will largely depend on both the detail and the implementation. ensuring that employers cannot select the easiest targets or targets they've already set for themselves, but rather that the targets are selected on the basis of progress and meaningful change towards reducing the gender pay gap. The FSU notes that the legislation does not include an obligation for employers to consult with their workforce prior to the setting of targets. We believe this oversight may result in poorer outcomes. We know that when the workforce is given a genuine opportunity to have a say in decision-making, the outcomes are always better. This legislation should be strengthened by including an obligation to demonstrate worker consultation has taken place prior to gender equity targets being set. While the FSU makes 7 recommendations in its submission, I wish to share some data that we believe supports these recommendations and the need for change as we strive for gender equality in our workplaces. Firstly, this legislation should apply to all reporting entities, not only those with more than 500 employees. With respect to the finance industry, agency data from 2021-22 and then 22 and 23 reporting years show that the total gap was 28.5 and 26% respectively. When we dig into the data, it shows that it's the smaller employers that have a much larger pay gap than the industry standard, while the larger employers have indeed a smaller gap. I take, for example, the 21-22 total gap for organisations with less than 250 employees. For that group, or that cohort, I should say, it was 35.2%. That's almost 7% higher than the average. And for organisations with between 250 and 499 employees, it was a whopping 47.7%, almost 50%, or close to 20% higher than the average. So for employers with more than 500 employees, the gap was smaller. And for very large employers, those over 1,000, the gap was at least 3% lower than for all organisations. So just on that data, we think it's clear that at least in our industry, in the finance industry, that organisations with under 500 employees have a lot of work to do to reduce the gender pay gap. And by extending the legislation to include these organisations, we believe that's a crucial step in reducing the gap across the entire finance industry. The FSU has long campaigned for ways in which employers can take steps to reduce the gender pay gap. For example, in 2019, we wrote to all major employers in the finance industry, outlining the impact of pay secrecy on the gender pay gap, calling on them to improve the culture of secrecy by not enforcing confidentiality clauses or to stop including such clauses in employment contracts. Not one employer took up that offer. In 2022, we again highlighted the impact of pay secrecy, this time specifically at the Commonwealth Bank, where we calculated that the gender pay gap was resulting in reduced compensation for workers by at least $500 million each year. When we put that to the Commonwealth Bank and asked them to further explain the difference in the gender pay gap, as noted in their annual report, when compared to the WGEA industry figures, they said that they look at remuneration of roles across the same level or classification, like for like, claiming that the WGEA methodology assesses roles that vary across the industry and therefore provides a broader view. As you can appreciate, we found this type of response from the biggest employer in the industry disappointing. It failed to address the complexity of the issue and rather sought to relegate it to just like for like, as that was the solution to the gender pay gap problem. It further underscores the need for meaningful targets, one that demonstrates that employers are committed to meaningful change. Last year, with the release of the WGEA data for the first time by employer, we saw that the median total REM for 2022-23 at the CBA was 29.9%. And yet the CBA 2023 annual report continued to publish a gender pay gap of just 1%. The 2024 annual report for CBA does acknowledge the WGEA data for the first time. And while at the same time, the report continues to say that on an aggregate level, they have achieved gender pay equity on a like-for-like basis. That is, men and women are paid equally for performing the same or comparable work. It was also during recent negotiations for the new collective agreement at Bankwest, a wholly owned subsidiary of the CBA, the FSU again asked what the current gender pay gap for employees covered by the EBA. The response we received at the time from the bank was to ask us to define what do we mean by the gender pay gap so that they could respond to the request. Of course, we emphasised that our request was made as per the WGEA definition. I wanted to share our recent dealings with the Commonwealth Bank as just a case study to just highlight the difficulties we experience in engaging with the industry in a meaningful way. I think I've demonstrated that on each of the occasions, it certainly is our view that the Commonwealth Bank hasn't taken seriously the issue. Rather, they've sought to challenge definitions or maintain the issue isn't as bad because they've achieved pay equity. 2023-24 data shows a reluctance to take no action as a result of the gap, with 88% of employers conducting a gap analysis, but 90% taking no action as a result of the gap, demonstrating what we would describe as a lack of commitment. And I think it's for that reason that we've recommended that employers must be required to set a target to reduce the gender pay gap, in addition to their 3 selected targets. The target must be meaningful insofar as to reduce the gender pay gap, not just report and analyse the drivers of the gap. My union has long campaigned for improvements to the gender pay gap. We've advocated for employers in the finance sector to be held accountable for setting measurable targets aimed at increasing gender equality, which we know will drive down the gender pay gap. Our submission addresses a range of ways that targets can improve gender equality. I've not referenced them all here in my opening remarks. Those include addressing the composition in the workplace, challenging the cultural norms that relegate women to default carers by encouraging a greater take-up of flexible work by male employees and others. I, of course, am happy to answer any questions that you may have regarding these recommendations later this morning. Thank you.
Thank you very much. Now to the HSU. Thank you.
Thank you, Senators. Thank you very much for having me. And I too would like to acknowledge the lands on which I am speaking from today, the Wurundjeri people of the Kulin Nation, and pay my respect to Elders past, present and emerging. The HSU fully support and endorse both the submissions of the ACTU and the FSU. It is the HSU submission, though, that setting targets alone is not going to be enough. Workplace need to be fit for purpose so that women are encouraged to stay and thrive within the workplace. The HSU has found that female members who work in the public healthcare system throughout Australia are subject, on average, to higher levels of insecure employment than those that work in the private healthcare system. Yet the private healthcare system has a far more rigid approach to flexible workplace arrangements, which our members are reporting prevent them from staying in or sometimes even entering in to that particular workforce. What this demonstrates is neither the public nor the private healthcare systems are encouraging women to stay within the workforce long term, and we sorely need those professionals to stay in those professions and build up that corporate knowledge. We are seeing firsthand it can be tough to attract and retain workers for reasons around lack of flexibility, increasing violence and aggression within the healthcare system, as well as long hours, understaffing, under-resourcing, and lack of empathy when it comes to women juggling with their own healthcare issues. Further, the gender pay gap in the healthcare system is alive and well. Data from the ABS shows a gap of $401.60 per week in 2020, and that's currently sitting at $390 per week. Therefore, the gap's only closed by $10 per week across the health sector within those 4 years in a female-dominated industry. Further, more data shows that the gender gap grows the larger the healthcare provider is, with a total gap of 14.7% for employers who have employees between 1,000 and 5,000 employees in 2021 to 2022. The HSU fully supports the submissions that you've heard this morning, and all the recommendations will ensure transparency and fairness across the sector and assist in gender equity long term. However, it's also the HSU submission that introduction of targets need to be although incredibly important, will also need to work with other workplace recommendations to ensure that the workplace is fit for purpose and allows targets to succeed, and that people are not being simply put in positions to tick a box to meet a target and ultimately are being set up to fail. We know that many employers within the health sector try to comply with their own gender targets, however, cannot attract the labour required. It is the HSU submissions that the targets will not work and that employers will also be set up for failure without the introduction of provisions that make the workplace fit for purpose and allow women to stay in the workplace and provide them with a safe workplace that works with them and not against them. That is why we've outlined in our submission particularly what is relevant to the health sector and what we're hearing from members, and that is the introduction of gender equal and safe workplace compliance code, which there is none in the health care system. The introduction of clauses such as reproductive health leave and the flexibility arrangements, introduction of reasonable working adjustments within the healthcare system, which are so historically rigid. By introducing measures such as above, along with the workplace targets, we can ensure that these targets are successful, and it's so important that they are successful for the reasons outlined by both the ACTU and the FSU today. The lack of gender targets is a huge reason why the pay gap exists. However, we need to ensure that women are set up for success within their workplace and they're not forced out of their workplace due to the lack of that flexibility. We know, for example, nurses on average are retiring across Australia at the age of 57 on average. That is too young to be forced out of the workplace due to issues that could simply be fixed through a flexible working arrangements, through conversations with employers. We also know that women in the healthcare system are more likely to be part-time, and that 42% of our members currently provide unpaid care for an average of 38 hours per week in addition to working. We know that 32% of women have altered their careers due to health reasons such as menopause, and 30% have used up all leave balances, and 14% have had to exit the workplace entirely because of reproductive health issues. So the HSU 100% endorses the proposal of targets, and we want it to succeed. However, it's our submission that there needs to be some underlying entitlements of flexibility and understanding that allows a proposal like this to work long term. Thank you so much for having me here today, and happy to answer any questions that the senators may have.
Thank you. We do have questions. If it's okay with you, Senator Colbeck, I'll let Senator Waters go first, as I know she has to drop out and come back in again. Senator Waters.
Thanks very much, Chair, and thanks, Senator Colbeck, for your grace there. Good morning, everybody, and really appreciate the time that you've taken to share your evidence and give us some very sobering statistics this morning. Can I start off with the ACTU? And apologies, I can't see you all on one screen because I'm working on my phone. So, Ms. Poldova-McLennan, in your submission, you recommend banning non-compliant employers from being eligible for Commonwealth Government grants and procurement. I'm supportive of that, as is my party. How do you think the bill could be made stronger to achieve that objective?
Thank you, Senator. Can you hear me okay?
I can, thank you, and hopefully likewise.
Yes, I can, thank you. Yes, so it is a key recommendation of ours that at the very minimum, non-compliant employers are also, not able to receive grants from the government, because that's currently not in the bill. In terms of how that's drafted in the legislation, I don't have specific words, but I guess I would take the opportunity to maybe give some examples of why stronger compliance measures are needed. So, affiliates regularly report that employers often are not reporting as they should. Their reports are either late or they're incomplete. And to date, there's been very little consequences for this. And as we know, there are no civil penalties to encourage compliance. Procurement, as I said in my opening statement, is perhaps not the most effective incentive here, because it's unclear to us how many DREs are actually involved in procurement, and without knowing that, it's really difficult to know whether that's a meaningful incentive to drive, compliant employer behaviour. So that's why I've said at a minimum, non-compliant employers should be barred from being eligible for Commonwealth grants, but that is subject to the same caveat in that we don't know how many of them are in the business of seeking Commonwealth grants. So again, it's an imperfect measure, and that's why we've recommended a system of civil penalties for non-compliance to drive good behaviour. I would just note as well that there was a recent review of the Modern Slavery Act in 2024, and that recommended the introduction of penalties for non-compliance with the Modern Slavery Act on the basis that it's incongruous to have a reporting duty on a fundamental human rights matter with no robust compliance procedure to ensure that people are compliant with it. And that review noted that it would promote the transparency objectives of the Act, that there are the same transparency objectives in the WGEA reporting regime, and that it was best regulatory practice to have a system of civil penalties where organisations are reporting to government or to statutory bodies. So the government agreed with the recommendation in its response to the review that the compliance framework for modern slavery needed to be strengthened, and committed to consultation on the introduction and operation of civil penalties. So we'd say we should learn that lesson up front here, and introduce civil penalties from the beginning.
Okay, thanks for elaborating on that. It seems to me that it's optional, and it's certainly they're saying that the existence of a certificate of compliance is a consideration when it comes to eligibility for a contract. But as I think you've highlighted, it's clearly not a barrier. It's just one consideration. I agree. Certainly that aspect should be strengthened and open to the conversation about civil penalties. Can I go now to job security? You recommend introducing a job security target. And we know that women, as you've all outlined, are increasingly likely to be in insecure work arrangements. Can you speak a little bit more about that recommendation for a job security target, please?
Yes, absolutely. And the affiliates on the line might have more to add as well in terms of the specific industries. But, it's been a massive issue that unions have been campaigning on for a very long time. And, thankfully, we have seen some recent strengthening of laws that have tried to address the issue of insecure work and its disproportionate impact on women. So we see every day in working with our members that a lack of job security can put an employee's life on hold. They've often got no guarantee of hours or even if they'll have future work. They are typically trapped in lower paid roles. The research that we've done in the past shows that they face significantly higher financial, physical and mental stress, less access to workplace training and promotions, and a much harder time balancing work and family responsibilities, which, as we know at the moment, disproportionately is an issue for women, although, of course, everyone would like to see that shift. We know that women are more likely to be in these insecure working arrangements, particularly because of that disproportionate burden of unpaid care that they carry. And the ABS data shows us most employees in casual work or fixed-term arrangements are women. So given, recent amendments to the Fair Work Act that put job security in the objects and in some of the objectives of the Act, consistent with that and the focus the government has given job security, we recommended including a job security target within GEI 1 of the targets. And, for example, this could require increasing the representation of women in a secure job, or reducing the number of employees on casual or fixed-term arrangements, and also labour hire workers.
Marvellous. I love that idea. Can I go now to Ms Marshall at the HSU? You've recommended introducing reproductive health leave, which is something that myself and I know the chair is also quite interested in, and we've run a separate inquiry about that. Can you speak to the impact that you think having 12 days of reproductive leave would have, particularly on improving women's workforce participation?
Absolutely. So we've seen, particularly in the healthcare in the health system, which is predominantly female, the average retirement age of nurses and allied health workers has been dropping. As I said in my oral submissions, the average age of a nurse at the moment retiring is 57, which is far too low given the workplace shortages we have in those areas. Further, we are seeing a lot of people having to take part-time employment because of their biological needs. So whether it's severe endometriosis, going through the IVF process, whatever it may be, they've used up all their leave entitlements, and we have had quite a substantial group of members who have felt they've had no choice but to change their mode of employment to part-time, casual, or enter the labour hire pool, the casual pool that get called in when there are shortages. So we feel that having these, and it's not just about the leave, it's about the flexibility and allowing those conversations to be had and allowing the workplace to be fit for purpose, whether that means more consistent breaks rather than one longer break, and ensuring that productivity. We're seeing across we've commissioned some research, and there has been some news go out that the cost of introducing reproductive leave across the whole of Australia, and I do have to emphasise this is an interim report, looks to be 920 million for every single worker within the Australian workplace. At the moment, we are experiencing a loss of $26 billion in lost productivity. So whether that be because people are taking unpaid leave, whether that's because people are just not productive in the workplace because they're in so much pain, and they're having to, as I said before, change their mode of employment, exit the workplace altogether, whatever that may be. That is the statistics that we're dealing with at the moment, that there is $26 billion of lost productivity in the Australian economy due to reproductive health. And we think that introducing such measures, more so around flexibility, would be instrumental in ensuring that women remain in the workplace, are able to build up their superannuation, are able to retire with dignity when they choose to, but more allowing the corporate knowledge to remain in the hospitals and in the disability homes, and allow the training for the new generation coming through and passing down that corporate knowledge, because there is a big gap in the training provisions within the healthcare system too, because we don't have the expertise remaining on the floor to train up the new generation coming through.
Sounds like a perfect storm. Chair, if there's time for me to have just one final question, and then that's great, thank you. Just to the FSU now, you've recommended that every employer must have a numeric target to drop their pay gap, as well as the 3 self-selected targets. Can you just elaborate on why you think this is needed?
Senator, the story or the example I shared around the Commonwealth Bank, I suppose, puts that recommendation into under a clear spotlight for us. The base salary gap in the finance industry is still at much higher than the industry average. It's at 20%. Employers in our sector have a better understanding of the causes of the gap. The data shows that they have a good understanding here, but they refuse to set the targets to reduce the gap. There are lots of things that they could be doing to improve the gender pay gap. I mentioned earlier our early request to end pay secrecy before it was legislated and outlawed. We still have big sections of the industry, such as the insurance industry, that are very reliant on discretionary REM models. They rely quite heavily on performance and market-based pay. We challenge that, of course, during collective bargaining. We're making some inroads across the insurance sector, but most employers there would continue to have some form of discretionary pay that applies. We also push really hard for a meaningful engagement through pay audits. I can't think of the last time we completed a pay audit in the industry. Again, bosses push back on that really hard. Through collective bargaining, we've been putting forward as part of our claims an appropriate dispute mechanism where we can work with the employer when an employee was to raise a concern about their pay. Certainly the experience of our members is that there are lots of people who are engaged for the first time on a market-based pay outcome. That pay is often much, much higher than the existing pay for those levels. It's a way that that employers use to attract employees into the organisation. We would like a mechanism that would allow workers, now that pay secrecy has been outlawed, to say, like, I've had a conversation with the person that I work with. I have concerns about my pay as compared to their pay. What's the mechanism that we can use? The ideas that we put forward are often rejected. And I think that it just demonstrates a real reluctance on the part of employers to take meaningful action on the pay gap. As I said, very high understanding. Employers in our industry conduct a gap analysis, but the WGEA data shows us that 90% aren't taking the action that's required to close the gender pay gap, to that point that I made earlier around the lack of commitment. I think it's for that reason that we want employers to set targets to reduce the gap in addition to their self-selected targets. We don't think everything they're doing is enough. We don't think they're going deep enough. We've, as I said, highlighted things that they could do. They're often not taken up by the employers. So if this is going to make a difference, then the target has to reduce the gender pay gap. It's not just about reporting or analysing the drivers, but actually saying we're going to do the hard work of looking at how we can bring it down.
Yeah, here. I think it's great to report on the gap, but if you then do nothing to close it, well, it seems a little bit tokenistic. All right, thank you so much.
Thank
really
you, Chair.
appreciate your
Thank you,
evidence.
Senator Waters. As Chair, I'll ask some questions now. Ms. Angrisano, I wanted to ask you, in terms of changes so you've highlighted that for the first time you've started to see a reduction in the gender pay gap. What changes have been made in the finance sector? Is it at the top level in recruitment at higher pay echelons, because that's easier to fix? Where have the gaps started to close and why?
I certainly think that the legislative changes around pay secrecy has helped. It is we commissioned some survey work with our members a couple of years ago, and again, it was very culturally strong in most of the workplaces that workers felt that they could not openly engage with each other, certainly not with their employer, about what they were getting paid. And we had some examples indeed of workers who asked the question of their colleague, I get paid this amount, what do you get paid? And unfortunately those colleagues were terminated from their employment. So there was and there maintains to be that fear of secrecy that bosses have enjoyed the kind of the cover of that. I do believe, however, that the changes to the law has certainly allowed us to advocate and encourage workers to be more open, and I think that is certainly helping. One of the things that we are starting to see is that employers are thinking a little bit more about, for example, the composition of the workforce. For us, this remains a really problematic issue in the finance industry. Whilst we've got almost equal parity of men and women in the industry, women only represent 36% of workers in that top pay quartile, to the point that you made a moment ago in your question. And on the flip side of that, they're 67% of the bottom pay quartile. We have part-time workers in the industry. It's a small percentage, it's only 12%, but of that, the majority are women. It's 85 or 86% are women. What we're doing is really raising the expectation with employers around how they can set targets to increase the number of women in management roles. We know that this will help challenge the cultural norms that lead us to see that overrepresentation of men in senior roles and in higher paid roles.
Are those higher paid roles? Yes, sorry.
Sorry.
You finish answering, and I'll then put in my supplementary.
Yes. So I think that we're starting to see a greater understanding by employers of the need to think about job composition, the segregation of work in the industry, and we're starting to see very early steps towards some changes that we believe are heading in the right direction.
So I'm presuming that the part-time roles are less likely to be in management or higher levels currently?
Exactly. They are the lower level entry roles, they're branch or call centre roles, for example.
Can I ask all of you what given employers can make a choice about which target they're going to strive to meet, which ones are they likely to reach for and why? And what place should unions really have in that conversation about not using that to paper over other all of the areas that we need to drive for better outcomes on?
Yeah, I'm happy to go first, if that's all right with the others. So I think, obviously the employer has to select one numeric target, and I think it's fair to say they'll select the one that they think is, easiest to be achieved. And other than that, we would expect that employers will be looking at the action targets which require just improvement of policies that they already have and that are pretty, low-hanging fruit and pretty easy to achieve. And don't require a lot of additional cost or things that they need to do. So that's what we would expect in the first instance. And in our submission, we gave an example of how if you don't require every employer to have a target of reducing the gender pay gap, you could just have an employer conduct a gender pay gap analysis, improve a policy, do nothing with the results of the gender pay gap analysis, and maybe appoint one woman to the board in 3 years. And, none of that is kind of super significant or meaningful progress, and it's entirely possible that none of that will close the gender pay gap. So that's the reason why that recommendation, which the FSW spoke to earlier, is so critical. On the role that unions should have in these conversations, I really want to emphasise here that it's a proven track record when you give employees a voice and trade unions and workplace delegates, you have better pay and conditions, you have better workplace health and safety, and you reduce the negative impact of workplace change, amongst many other benefits. Unions have obviously been, engaged in achieving gender equality for decades through collective bargaining, through test cases, through campaigning for entitlements like carers leave, like paid parental leave, like paid family and domestic violence leave. And union members are paid, the ABS data continues to show us union members are paid higher and have better conditions of work than non-union members. So unions play a pivotal role. They have substantial knowledge and expertise on what works to achieve gender equality and what works in specific sectors and industries and workplaces. So it's our argument, our submission, that workplace cultures just won't become more equitable unless workers and unions are involved in those conversations. And so what we've recommended is that they should be consulted on what targets the employer selects in the first instance, what action they plan to take, because again, we'll have so much to offer in terms of what works and what genuinely shifts the dial, the implementation of it and how that can be done well. And also that another key issue here is consultation. So we've recommended that employers agree basically how to consult their workforce with workplace delegates and their unions as a first step. And the reason we've recommended that is because the targets that are currently proposed would establish alternative means of consulting employees that aren't independent of the employer, and they seriously risk undermining the representative role of delegates in their unions. And so what we often see happening is employers will set up structures or bodies that bypass or undermine union structures and delegate structures who are representative, and they'll set up a separate committee. They might handpick representatives to be on that committee, and then obviously that committee ends up being effectively controlled or subject to sort of management influence rather than being truly representative of the workforce. So That's why we've made the recommendations we have on consultation and involvement of delegates and unions. There's a real opportunity here for employers and unions and delegates to work in partnership to accelerate progress on gender equality.
Thank you for that contribution.
Senator, would it be okay if I
Yes.
just jump in there on that point of consultation? I really wanted just to emphasise that, the idea of making sure that consultation is genuine and it's not just a survey, for example. Sasha's already outlined the deficiencies with something like that. The 24 data indicates that in our industry, 85% of employers undertook consultation by nature of that survey. And the surveys, they're often long, they cover a range of issues, they're mandatory, they often form part of your performance and targets, which can have an outcome on your pay. So, we don't think that that comes close to meeting the requirements of genuine consultation. A few years ago, as we were preparing for the new positive duties, we undertook engagement with members and workers in the industry alongside employers. We wanted to ascertain how the new positive duty had changed and whether or not it was changing, I should say, the ways that managers were managing the risk of sexual harassment, and to compare that with the lived experience of workers. And what all the employers told us was that based on their risk assessments, and those risk assessments, they all came back as very low, showed that didn't necessarily correlate with the experience of what workers were telling us. What workers were telling us was that they found they weren't clear about what behaviours constitute sexual harassment, for example. And employers were relying on these staff surveys, whether they conducted them themselves internally or through external consultants. And they were saying, well, the surveys are telling us that workers are not experiencing sexual harassment, therefore the risk is low. But when we broke down and really asked workers about their experience and asked them about the behaviours that are commonly understood to constitute sexual harassment, well, that jumped up to 40%. And many workers told us, well, I've experienced that behaviour. They just didn't understand that it constituted sexual harassment. And I just wanted to share that as an example because I think it just demonstrates the gap between, understanding the nature of sexual harassment or the nature of the gender pay gap, for example, and workers who don't necessarily see it directly. And so relying just on a survey alone, I think really misses the opportunity for genuine input by workers and their representative unions.
We are shortly to run out of time. I just had one last question, but I'll allow us to go over a little and then I'll make sure Senator Colbeck's able to complete his questions. So can I ask, does the existing data collection and that enabled through this legislation enable you to monitor all of the gaps that are currently set out in the legislation that our employers are choosing from, if they choose one? Will we have transparency over the fact that organisations may have chosen the easiest target to meet, and how will you use this information? Because clearly you do use this information, and yet you may or may not be disconnected from the consultation processes about how targets are achieved. Who would like to jump in on that one if you understand my question? And if you've got things you would like us to work through as a committee in asking questions to help highlight how you might go about looking at that. I think there's a general alignment and that we would still have transparency over all of the target areas. What I'm unclear about, that I still need to unpack, is the extent to which a new target might be generating new data, or the target that is selected might be generating new data.
If I could just clarify your question, Chair, and I think there are a few different things in there.
There certainly are.
About what we know our affiliates use Woodea data for, but is that the last point you were talking about, whether putting new targets in there is going to be, generating new data in that employers will need to be reporting additional things to what they already report?
In part, yes, but also that whether we can identify, if you like, whether an employer has simply chosen the easiest target to meet. That is, they were nearly there anyway, and you could see that in the existing data, for example. For example, something like board appointments.
Yeah, look, I think that's a really good question. I probably defer to the affiliates on the line who have real world experience of using this data. But that would certainly be our hope, that it would be possible to identify whether they're choosing those easiest targets. I guess, for example, with the board appointment, unions, that information will be publicly available. It'd already be reported to WGEA, so it'd be easy to see, oh, well, they've just chosen to finally put a woman on the board after 3 decades of not having one. But yeah, I might get the affiliates to say more about that. But
and feel free to take all of these questions on note, that set of questions on notice too.
Yeah, so
do
that. Thank you. In terms of, so we have heard from our affiliates that they do use WGEA data a fair amount, both in, campaigns to push gender equity measures and also to engage with employers and workers, their members, about gender equity issues and to try and drive change in workplaces. And the data really helps to, focus on what the real problem areas are and where there's a real room for improvement and, what's going to have the biggest impact on gender equality in that workplace. So the data is super useful, and, the WGEA reporting framework in general, I just might take the opportunity to say, is incredibly valuable in the Australian, economic context, and where we're very grateful it exists. Look, there are some limitations with the current framework that do hamper the efforts of unions to drive real change, and one of those is the lack of requirement of consultation with unions and delegates. And the other thing our affiliates find is that often employers aren't providing them with a copy of their report to WGEA. So they're required to provide them, I think, with notice of lodgement, but they don't actually have to provide the report. And so you've got this really silly situation where unions are saying, because often there's a time lag before the report's published online, and unions wanted immediately to start doing that work and, use the momentum. And there's this silly situation where employers, refuse to give it to them, and then there's an opportunity lost to use all of that data, to make change. So I'll just say that, but I'll hand over to the affiliates if they've got something to add.
And please do just feel free to take that on notice, noting we'll need a fairly short turnaround on it.
I would only just add the usefulness, and I focus in on that CBA example again, where we were able to use the data for the very first time by employer when it was publicly released last year to highlight the gap between the WGEA data and the WGEA methodology as compared to what the CBA was reporting publicly in its own annual report. So I would just use that as a point to highlight. We see it as incredibly important to really continuing to press for change and seek the advancements around gender equity in workplaces.
Thank you. Senator Colbeck.
Thanks, Chair. Thanks very much. I just want to go back to the evidence from the Finance Sector Union in relation to the Commonwealth Bank's interpretation of where it sits. Its report, it talks about a 1% difference versus the WGEA data, which is obviously quite different, although it is now acknowledged in their report. Is there? Do you think a need to have some stratification in the data so that the areas that are driving the differences, and you've talked about those in your evidence, are actually more transparent in that sense? This debate gets hooked up in an argument of equal pay versus who's employed whereabouts in the business, and that becomes the focus of the argument, if you like, in a lot of circumstances. And yet, the debate that we've been having this morning is more about stratification of employment within the businesses. Is there any value in data that would support that understanding of that better? in your view, would that actually drive changes in the way that behaviour? You talked about access to the data being critical in your view in driving some of the movement in the last 12 months or so. So how would those things work in your view?
Senator, I think that improving transparency on all data is a positive thing. I would say that in terms of the data that the Commonwealth Bank relies upon when they look at this through the lens of like-for-like jobs, I suppose we would say that for many, many years, decades in fact, the gender pay gap across the finance industry has not come down. So if employers over that period of time are looking at it only through that lens, improving that data alone won't be sufficient because, you know, it is a very complex issue and there are a range of things that contribute towards the gender pay gap across the Commonwealth Bank or indeed the industry. So I think that greater transparency, really understanding the role that data can play to challenge, you know, why is it that the industry gap is still at 20%, the Commonwealth Bank is at 29%. They've got data that shows it at like for like at 1%. I'm sure Commonwealth Bank is looking at the issue in its totality. It's just that when we engage with them, it's very hard for us to get them to go beyond that. In all of the examples that I gave, whether it's in bargaining, when we raise it at the time of WGEA dropping their industry data. So we would welcome greater transparency on all data, but I think it's whether or not we can actually set targets that are going to improve that gender pay gap across a range of areas, everything from composition to the roles that women are holding. We spoke earlier about we've got excellent policies across our employers. A very high number of employers have excellent policies with regards to paid parental leave, for example. And yet, and many of those employers are moving to a more family neutral understanding of parental leave and moving away from those gendered primary and secondary carer responsibilities, for example. And yet, despite those excellent policies, we still have the majority of workers who are taking up parental leave remain to be women. So I think that there's a whole range of issues that we should be considering here as part of the steps that we can take to reduce the gap.
I was also interested in the evidence from the Health Services Union in relation to a lot of the issues, particularly the retirement age around nursing, and having spent some fairly intense time engaged in that sector. Curious as to whether the demand for people, which is pretty significant at this point in time, is actually driving any of the changes that you expressed as being desirable in relation to employment, because wherever I go, public discourse about the health system, but also my engagement, particularly with aged care over the last 3 or 4 years, 5 years, significant demand. Is that actually driving some positive change in respect of some of those employment conditions that you've talked about?
No, not really. So what we're seeing is because of the, I suppose, the fact that a lot of healthcare providers are quite rigid in their approach, there isn't the chance to have that flexibility or that conversation about what's required. We're seeing more and more people move into the becoming sole traders and becoming registered under the NDIS and working for themselves and working the hours that suit them, and being able to, charge as per the NDIS. We're seeing there's a greater shift towards that there are a lot of people who are becoming registered and getting ABNs. We are actually seeing that a lot of people are doing that in addition to their employment as well. So they're not necessarily giving up their employment. They're becoming part-timers or casuals, and then supplementing their pay with this idea of becoming a sole trader to give their income the appropriate boost. We are also finding that when those high-level directors, those sort of roles within particularly the public healthcare system are advertised and being interviewed, although a lot of our members are being successful in getting interviews, it is a very small proportion of women who actually fulfil those higher level roles too, and it is actually becoming a bit of a conversation within the public health system of why even try now. So people aren't even putting up their hands for those roles because they see it as a waste of time because they're not going to be able to get those roles because of, whether it be, as I said, reproductive health issues or safety concerns as well. And that's just adding to what the FSU said before around sexual harassment in the workplace as well. We're actually seeing a lot of women leave the workforce for that reason, not so much yes, they do understand there may be some success where they don't actually comprehend that they are being sexually harassed, but there's also that mentality of people who work in the disability sector or in the mental health sector who are in some cases sexually harassed or sexually assaulted quite severely, but deem it as part of the job. And they didn't know, the patient didn't know what they were doing, the client didn't know what they were doing, they didn't mean it, it's just part and parcel of the job, but then they exit their workforce due to their own mental health concerns as well. So we are seeing quite a rise in that lately as well. And what we're seeing employers do is rather address the sexual harassment or assault complaint, they're actually moving that that health professional to another part of the hospital or to another care home, which really isn't addressing the issue. So, no, I suppose that's a long-winded way of answering your question. There is a high demand, but yeah, we don't see people knocking down the healthcare system's door to try and get in, unfortunately.
But so you're not even seeing any change.
Sorry, what was that?
You're not even seeing change in respect of the public sector, which normally perceived to be the leading in some of these sorts of provisions in introducing them. You're not seeing any change or movement within the public health sector, even in respect of these matters.
Sorry, you dropped in and out there a little bit. As far as matters as in the introduction of some targets, or
just changing in the way that they manage some of the issues that you've been talking about.
No, not enough change to report, I suppose. That there may be, I can think of one or two employers that have seen a small change, but on the whole, no, not a massive change.
Okay. Well, I think between you and Senator we've covered most of the things that I wanted to deal with, so I might leave it there. Thanks, Chair.
Thank you, Senator Colbeck.
Could I ask briefly, Chair, am I just able to add a very brief comment in answer to your questions from earlier? In relation to whether we'll be able to identify whether an employer is choosing the easiest targets, I think that's at a granular level that might be a more appropriate or a question that WGEA might be able to answer in terms of how that's all going to work. But what I would say is that, and it goes to the question you asked about what targets will you expect employers to choose? I would definitely expect them to be choosing the targets that are replicating existing legal obligations, of which there are a few, and particularly in GEI 6. A lot of the targets there, as currently drafted, replicate what employees are required to do under the positive duty. So I would expect to see employers choose those because they're already required to be doing them, and they'll already be doing that work. And, just goes to the point that We need those targets to continue to be robust and meaningful going forward, and there will be a need to review them and update them as time goes on to make sure they stay relevant and to make sure they continue to be appropriately stretching of employers.
Thank you. Thank you for that answer, and thank you to the ACTU, the FSU and the HSU for your evidence today. We will now invite the Australian Industry Group to the table, and I'll just let senators and witnesses know that we will, if it's okay with everyone, go a little bit into the scheduled lunch break so that we can have enough time with AIG.
Thank you. I'm just confirming that I'll be jumping off the meeting.
Thank you. Yes,
Thank
you're
you.
welcome to go, and feel free to watch online.
Thanks very much.
Thank you.
Or do you need us to check?
Yeah, no, I just needed to find my paperwork. I'm now pleased to welcome representatives from the Australian Industry Group. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. For the Hansard record, I'd now ask each of you to state your full names and the capacity in which you appear.
Thank you, Chair, and good afternoon to Chair and members of the committee, and thank you for the opportunity to appear before you today. My name is Louise McGrath. I'm Head of Industry Policy and Development with the Australian Industry Group.
My name is Yoness Blackmore. I'm a Principal Advisor in the Workplace Relations Policy team.
Thank you. I now invite you to make an opening statement. Will you both have one or
no,
just one?
Just one.
Thank you.
I'll give a shared statement. We thank the
Thank you.
We thank the committee for the opportunity to provide further assistance to the inquiry following our written submission we made on the 16th of December 2024. As you may be aware, AI Group is a peak national employer organisation that represents employers of all sizes conducting business in traditional, innovative and emerging industry sectors. We support and advocate the advancement of gender equality and other measures that contribute to safe and respectful Australian workplaces. Significant improvement across a range of gender equality indicators has been made in recent years, with changes in societal factors, economic and labour market conditions, workplace regulation and the actions of employers all contributing to this positive development. We also commend the ongoing efforts of the Workplace Gender Equality Agency in providing support to businesses to understand their obligations under the WGEA Act, including through masterclasses, workshops, guides, case studies and tools. However, we do have serious concerns about the bill as proposed because it will create significant unfairness for our members, particularly in relation to the proposed application of the targets to government procurement eligibility, which, in our assessment, removes the existing discretion for procurement officers to consider gender equality within the procurement process, discriminates against businesses with over 500 employees, which contradicts the core principles of the Commonwealth Procurement Rules and the WTO, World Trade Organisation Agreement on Government Procurement, of which Australia is a party. It applies a discriminatory and unfair way against employers who have made significant progress. It creates an unfair competitive environment for domestic as compared to overseas businesses, will result in different targets being applied to different businesses, which undermines the principle of competitive neutrality and a level playing field, provides no certainty on what is a reasonable excuse, instead leaving it to WGEA's discretion, and fails to provide an external mechanism for a review of WGEA decisions, despite these potentially having a significant financial impact on a business. We also ask the committee to consider the following. The principal objects of the WGEA Act are focused on WGEA promoting gender equality in employment, including by supporting employers to improve gender equality in employment and the workplace, and by doing so to improve the productivity and competitiveness of Australian business. However, potentially punishing our members by rendering them ineligible for government work is entirely inconsistent with these objectives. The WGEA procurement principles were developed on the basis that WGEA was a light touch regulator that works collaboratively with employers, business and industry, offering advice and assistance, including access to training, online tools and resources to promote and improve gender equality in their workplaces. Locking members out of government procurement is not light touch, and it is not collaborative, especially in circumstances where there is no ability for members to adapt targets during the 3-year period. Reasonable excuses or failures to improve or achieve the targets are all at the discretion of WGEA, and where members have no access to external review mechanisms. Submissions made to the committee from other stakeholders do not refer to any research undertaken or provide any substantive justifications as to why it is necessary or desirable to include this enforcement measure in the bill. It is significant and completely unsatisfactory that neither the impact analysis addendum accompanying the bill or the impact analysis related to implementing the recommendations of the WGEA review report have undertaken any specific analysis regarding this procurement eligibility measure, despite the fact that it may have significant adverse effects on our members' productivity, competitiveness and financial performance, and in the face of a plethora of business challenges. On that basis, we recommend removing this mechanism from the bill. If, despite our members' significant concerns, the committee recommends the passing of this bill in its current form, we respectfully request that the amendments to the Act should be subject to review, ideally within 2 years of the amendments being made. And with that introduction, we'd be pleased to take any questions.
Thank you. Senator Colbeck, would you like to go first?
Sure.
Or please go ahead.
Okay. Thanks for your submission. Thanks for your opening statement today. We've had evidence about increasing the scope of the legislation as it's proposed to include more businesses. Do you have a perspective on that evidence? I mean, your evidence talks about discriminating against large employers, but increasing the scope of this to, for example, as a finance sector union said, to all businesses within that sector. A perspective on that.
So, Senator, is the suggestion to include businesses of all sizes which would be subject to these new obligations, which would also have an impact on the government procurement eligibility? Is that correct?
Yeah.
Yes. Well, our position would still be the same, even though we do highlight the discrimination against employers of 500 or more. They're the ones who are currently in scope. The cost of complying for all businesses, I think, would actually be beyond the capacity of some of the very small businesses, but also, again, would put Australian firms at a disadvantage to foreign firms in government procurement, and in a time of high inflation and cost pressures would actually cause government procurement costs to rise, which would have a significant impact on the economy.
And if I could add, if I may, Senator Colbeck, we would really object on behalf of our members to anything that would increase the amount of red tape, extra work that they need to do on these types of initiatives in communicating and reporting back to WGEA, in an increased scope from what they do now.
Has there been any cost analysis on compliance done on any of these and these systems? Do you know?
The cost of compliance?
Yeah.
We have anecdotal feedback from members that, I had one member say, well, we're coming into the season, so 3 months I'll be offline working on this. I do think, businesses are not, do not have access to infinite resources, and every decision is an opportunity cost of another decision. So applying resources to even just reporting means that those resources cannot be applied to production or to marketing or to R&D. And so it's sometimes difficult to quantify because it will be unique to each enterprise, but there is always a cost.
It's probably reasonable to say that different businesses have taken different approaches to this over a period of time. Some are way more advanced, if you want to put it in those terms, than others. Does this process support the businesses that have actually made greater effort in advancing this issue than those that haven't, or does with respect to the new provisions, do they take into account the fact that some businesses are well down the path, and quite often the last yard is the hardest yard, if you like, in that sense? Is there a risk or concern that this legislation doesn't take into account the work that's already been done by some businesses in making those significant gains in the way that the new provisions work?
Yes, there's grave concern, particularly from those members who currently have government procurement contracts and hoping for renewals. They look at their competitors who have not made similar investments, and the challenge with this act, with these new amendments, is that the past work is not counted. So the slate is wiped clean. You must show progress from the new moment in time, from where you were at, not where your competitor is at, which means that, as you correctly identified, those companies who have already made the investments, have already taken significant action, losing all that work and essentially starting from scratch once again.
So how would you modify what's being proposed to ensure that effort already undertaken is actually considered and taken into account as part of the process? I mean, you want people to be taking the appropriate action. Surely there should be some way of recognising and rewarding that, rather than saying, okay, that happened yesterday, but we're forgetting about all that and starting all over again.
Thank you, Senator Colbeck. The members that have been able to implement measures to improve gender equality in the workplace really should be able to restate those measures as part of the proposal, to give them the opportunity, therefore, to show everyone that they've made these achievements. So it could, in effect, be very beneficial for those members.
And may I also add, Senator, we understand the need for progress, and we should all be aspiring to have, constant progress over time. That the challenge with some of these measures is they do capture a singular moment in time, and so you can't really demonstrate progress of. You can't demonstrate the expected progress of the investments you're making today that you hope will have impact in perhaps 5 to 10 years.
And adding to that, Senator Colbeck, my apologies, is, I think we really need to recognise that as you get to what might be described as more difficult measures, which of course will depend on the employer anyhow and the challenges they're facing, we are talking about workplace culture here and cultural initiatives. You don't change those things overnight. And many of our members, have legacy issues. They may have super strong equitable practices, but they still face difficulties in getting improvements in these areas, particularly in industries like construction, trades, technology and energy. And, it's not just at the employer level. The employer is not solely responsible for this, because there's a long pipeline leading into this. For example, in engineering, I think there's a 20% females actually doing the qualification at university, and that already places some of our members at disadvantage.
Look, that's a good point, and I suppose it leads to changing some of the cultural norms that drive community, therefore business and industry perception in these issues? How do we, from both perspectives, I suppose, you talked about construction, for example, which is my background, and when I did my apprenticeship, the concept of a female apprentice would not have been something we'd thought about, yet the current Tasmanian apprentice of the year is a young girl from just outside of Devonport, where I live, which is fantastic. But conversely, in some of those traditional roles that have been seen as caring roles, which are heavily focused the other way, how do we drive recruitment and training into those roles in a more gender balanced way, which is actually what's going to assist to drive evening out the numbers in those roles as well? It works from both sides of the equation, doesn't it? How do we start to changing the perceptions in those across the board, if you like, in that sense?
Thank you, Senator Colbeck. I mean, WGEA itself is very supportive in this way, because they have a whole lot of work design measures and different things that employers can try to implement to, bring about this change. So, they have different measures that they suggest for recruitment, different measures that they might suggest for promotion, and it's that collaborative working with business that actually helps push through, these difficult cultural changes. But I suppose I should just, not to reiterate that point, but construction industry has actually put in significant measures, good, a lot of our members, excellent paid parental leave, flexibility, various measures, encouraging men to take parental leave. But all these changes, all these measures, just take time. So we just have to keep doing these things. And more generally, perhaps government, puts resources into business to encourage through the education system and so forth. These WGEA measures perform an important part of that to support businesses. And I think that, in combination with all these other things, will help to achieve these sort of changes.
Okay. I think I might leave it there. There may be something I come back to, but I'll just go back through my notes.
Thank you, Senator Colbeck. I would like to ask, sorry, I've just got to bring my notes up. I guess I'm struck by your evidence of alarm around concern about the powers of WGEA. I guess, will your members really have that much difficulty in choosing a target and meeting it? Surely, as it's discretionary, as you've already highlighted in your evidence, WGEA does good work supporting organisations to work through issues and provide advice, and there'll be other supports in terms of choosing a target and meeting it. I would expect, do you have concern about your members really being able to choose a target and meet it without being sanctioned, realistically?
Well, I think that the challenge centre is that the company must choose the three targets of the selected, menu, and as discussed, can't necessarily choose targets where they've already complied. So it's new work. 3 years is quite a long time, and there's no scope in that time to adjust or to amend or to change the targets, and all sorts of things can change. There are, could be changes to the leadership team, there could be a restructure, there could be a merger, there could be a market shock, all sorts of things, so that there's just absolutely no flexibility. And if we think about...
Would you not expect WGEA to... sorry, please finish your answer. I rudely interrupted you.
And the issue that's been highlighted by a number of our members, if you think about large renewable projects, which is a standard government procurement project, those contracts, those negotiations are actually often longer than 3 years. But when you're putting in your bid documents, you need to put in the cost of labour. And so with, as I said, all those variables, potential variables in that time, and the lack of ability to change, that cost of labour could be significantly changed, which would mean they're no longer competitive in that tender process.
Sorry, Senator Pratt, I was wondering if I could add to that, if I may. We spoke earlier about, and obviously you can tell that Australian Industry Group has a lot of time for WGEA and a lot of respect for what they're doing. WGEA's role is a light touch regulator. So what we're talking about here is something that is going to potentially have a big financial impact on a member, even if they're making best efforts. So in the context of light touch regulator, having the discretion and relying on WGEA to be there to support and to determine if there's a reasonable excuse and so forth, that is something that we've all been working with more generally with WGEA for some time. But we're now talking about a situation where often in tight timelines or deadlines for procurement that we're waiting on WGEA to exercise, hopefully, a good discretion for us, but it could actually have quite a bad outcome if that discretion isn't exercised in a member's favour. They think it should be, and then added to that, there is no review mechanism, no independent, third party that someone could go to and say, hey, look, actually, that we do think we have good reasons because of merger and acquisition. The data collected doesn't reflect the broader set of things that we're putting in place to have a safe and respectful workplace that includes gender equality. Thank you.
So you don't trust WGEA to have that level of discretion required. So, for example, if a company truly is an outlier and hasn't met its targets and hasn't been subject to mergers or acquisitions, surely if we weaken that proposition that WGEA does have the power to make a recommendation that they be precluded from procurement, that, we need to, if a company is an outlier, that we need to really put those incentives in place to drive that movement. Because we're not, if someone is working in good faith, then you would expect that discretion to apply.
But all these elements are subjective, Senator, and that's the challenge. And these are very, 500 employees plus, so often there is a foreign owner and who aren't necessarily aware of the Australian context as such. They're making investment decisions on which branch that they will give certain IP to, certain products, certain investment. And if there is uncertainty, often in these investment decisions, you're looking for any exception. So if there is uncertainty, there is a risk that they may invest in other markets, not in Australia.
Surely we would be considering in that context that we want investors in Australia to have regard for making that positive contribution to gender equality in the workforce, and that this is something that this kind of mechanism is something that will bring attention to investments decisions and to the board about a capacity of a company to make progress if they're lagging behind.
Potentially, but these investment decisions, are made using a wide variety of inputs. This would be only one element.
And Senator Pratt, I'm wondering, sorry to interrupt you, we need to also remember that individual employer gender pay gap information and, the broader sort of set of numbers that come around that were published last year and will again be published this year. So that in itself in our members' views, is a significantly strong incentive to be making changes to support improvements in that number, because it's there for everyone to see. The targets that are being proposed are measures that sit within that, and I would have our members would be putting that in itself is sufficient. There's no need to have, or no justification, certainly, looking back on the review report and the impact analysis, for going that extra mile at this point in an area that is difficult to measure, takes time for change. In the same way, it should be small steps to bring in the compliance and enforcement, rather than going in the beginning in such a significant way that can have such potential impact when the government is not even, aware whether that's necessary.
Well, I would put to you that, some of the existing targets that are reported, things like, do you have equal opportunity processes within the company? These are, some of them are areas where there are existing obligations for employers, and that therefore they should be meetable under existing frameworks. And we're simply, in effect, we would be sanctioning, the failure in some cases to meet basic legislated existing standards.
I just don't have the menu in front of me, sorry, Senator Pratt, but there clearly are things in there that employers would be doing. So, those actions that employers are doing to try and achieve change, they're on the menu. Targets, yes, but there are also numeric things on there. And if we go back to, if we go back to thinking about employers that have actually put a lot of things in place and have still not been able to make progress, maybe viewed as a laggard despite those challenges they're facing, they then need to move on to, say, a commitment to improve the gender pay gap.
So, I'm pretty committed to the need for retaining this ability to have a sanction from WGEA. But so can I ask you in turn what you would like to see in WGEA's processes when it comes to the kind of meaningful dialogue, which you say they're already doing? What needs to be in place to ensure that those processes and that engagement is robust, so that regard is had for perhaps extenuating circumstances, regard is had for best efforts, and regard is had for some of those circumstantial things, like, for example, a takeover, etc., where you bring in a liability from elsewhere.
So I think there's a couple of things that I'd suggest, Senator, and I think Jonas might have some more after I finish. But one would be the ability to change the targets over that 3 years. I think if, as you say, with a fair and reasonable excuse. The other is some certainty on what compliance looks like, and thirdly, acknowledgement of prior work. I think that's, in our consultation that we mentioned in passing, we think some members, certainly in the first round, the first sort of 3 years, would easily meet some. We were advised that no, they were not allowed to choose those. They can only choose things in which they can demonstrate progress. We do think that prior work should be acknowledged, because otherwise you are essentially rewarding laggards. And Jonas,
did you have further questions, Senator Colbeck?
I'm wondering, Senator. Sorry, you just mentioned that you wanted both of us to. Yeah, I'm sorry. If I just quickly, my apologies.
Of course, no, my apologies.
No, it's fine. Sorry. To add to Louise's points, WGEA would need to have a lot of guidance and materials on reasonable excuse. It would be additionally useful if there was a review opportunity, if a decision wasn't agreed with. It would be ideal if there was some type of time frame on a decision making so that that could then align with any procurement. And in terms of the selection of the targets and rules that are currently attached at the back of the explanatory memorandum, we would ask that on behalf of our members that we could consult more specifically on those targets and the rules that are attached to them. At the moment, the Minister will do that in consultation with WGEA. And thank you very much, Senator Pratt.
Thank you. Senator Colbeck.
I was actually about to go to exactly those points with respect to reasonable excuse and what would trigger a review process. So do you have any thoughts on what I think you've mentioned some of those things already, but how would we formulate something that would actually, in a process sense, permit the review process, but also quantify what a reasonable excuse, if you want to use that as terminology, or a reasonable reason for the fact that you're looking to review the targets that have been selected?
Yeah, we might take that one on notice, Senator. I mean, we don't want to suggest an AAT review. I think that would be excessive. And of course, we're very much focused on non-compliance for when it's linked to government procurement, but there's all sorts of other reasons why a company over 500 employees who doesn't need a certificate for government compliance but is still determined to be non-compliant would still like to review that process. So we don't want it necessarily linked simply to government procurement. But if we could take that on notice, please.
I mean, I'm thinking about it in terms of, and I agree. I don't think running off the AAT is necessarily the option, but it's about that, let's say, cooperative process that we've talked about with respect to working with GEA to achieve outcomes, and potential circumstances or events that might drive a point in time where it's not necessarily that you're not wanting to achieve an outcome or a target you've set, but you're not because of the circumstances, and being able to have that conversation.
So I think certainly a force majeure event, a merger and acquisition come to mind immediately. It could be Department of Finance, could be the review mechanism, which is separate to WGEA, but also understanding of government procurement.
And Senator Colbeck, I suppose just not to labour the point, but for employers that do many of these things and have very strong equitable practice, to understand what reasonable excuse might be in that context where there's a lot of different drivers for example, if a big construction employer had a lot of the recommended things in place and had been unable to make a numeric target, so they'd already ticked off a bunch of the menu things, what would be a reasonable excuse in that context? Because there's obviously a broader set of influences that may result in that failure to meet, that particular number. And I suppose in this context then, the idea of improvement, what is improvement anyhow? We've got this number that says you achieve this gender pay gap reduction. What does improvement actually mean in that context? And part of maybe moderating the type of review that is needed is to enable that discussion throughout that 3-year period as to whether a target could be revised. So, for example, if they weren't able to meet that gender pay gap despite best efforts, perhaps there needed to be some adjustment around that.
Yeah, I mean, we've seen some examples or some discussion, I think it's probably a better way of putting it, of workforce pushback in relation to this. And it goes a little bit to some of the cultural norms that I've talked about on both sides of the equation, where people have traditionally been seen in various roles. And clearly that's that's a changing part of our community. How do you manage those sorts of things where you might have a circumstance of workforce pushback? I mean, we had conversation from the unions about it from their perspective earlier, but I think Rio Tinto, for example, reported some things in November last year where their workforce were pushing back against some of these things in relation to how various of their members of their workforce felt they were being treated from both perspectives. Actually, how do you manage that in the context of what we're talking about here?
It's an important issue to raise, I think, Senator Colbeck, and I'm sure I read some research that WGEA itself had noticed that there has been an increased in what you might call backlash or gender fatigue. It's a difficult thing to deal with if we're looking at it as a zero-sum game. I don't think there's an answer on it, but certainly with the more defined the targets are, especially the numeric targets, perhaps the more difficult it is to communicate that, particularly when people have a lack of understanding of what the data means under the Act in any event.
I talked with the unions before about how the definitions are perceived, if you like, and or reported. And where some of the differences actually come from versus what people think they are. Do you think that there's any value in ensuring that the data actually reflects the things that are the drivers of what's reported as the workforce gap in a better way so that people understand those things?
So WGEA does actually drill down and provide quite granular data. The difficulty is often that people might perceive it just to be about equal pay. I don't know if a solution is, there may be arguments as to what the data reflects, but in terms of what WGEA produces, well, it produces quite granular data already. And they're focusing on different things each year as they look at how various employers progress. So I'm not sure whether our members would think that, additional data points would be helpful.
And may I also add, Senator, I just observed that WGEA as a whole are experts in gender equality and workplace culture. I think they're not necessarily data specialists, and some of our members do question the way some of the data is calculated. We do think there might be some value in having data specialists such as ABS or someone to assist them with that formula. And the other thing I observe is, as I mentioned before, these reports are a moment in time. They don't necessarily demonstrate the investment for the future. So we've talked a lot about construction. If a construction firm decided that this year 90% of their graduate intake of engineers would be women, suddenly their pay, junior engineers, no matter what their gender, are not paid very well. So suddenly their figures look wrong, or there's a gap in their figures, but it also doesn't tell the story of what they expect to happen in 10 years.
Their figures would go backwards because of the fact that a junior engineer receives less pay than a senior engineer, and so that would be a blip down in their numbers, and yet what they're looking to do is to create a greater parity across their business, which would, over time, even out.
That's right. And so that 10-year perspective is not given in that singular report.
And Senator Colbeck, it's a very good point. We would say on behalf of our members that it is, it's a long game. It's a process to get there. It's not that our members are not committed to achieve change. AI Group and its members all support safe, respectful, equitable workplace. These things just do take time, and sometimes it may look like you're going backwards, but you are actually in that long term going forward. Like And even if we get the 90% people coming in, you've still then got 6 to 7 years of making sure that they stay in that pipeline so that they then would be able to take more senior positions in the organisation. And I suppose on the 90% and thinking back to backlash here, you obviously have to challenge a whole lot of competing considerations here.
Yep. Okay. Thanks, Chair.
Thank you to the AIG group. I wish we had more time for questions, but we'll now move to a lunch break and reconvene at 1:20. I think that's right. I'm in Perth. Yes, 1:20 p.m. and we'll see our next witnesses back online then. We'll now suspend until then. Thank you.
Thank you.
now resume after lunch. I'd like to thank Dr. Leonora Risse, Associate Professor in Economics, and if you can correct pronunciation for me, that would be great. And on that note, I'll invite you to introduce yourself to the committee and the capacity in which you appear.
Thank you very much, Senator Pratt, and thank you to all the senators for the opportunity to contribute to these hearings today on the Workplace Gender Equality Setting Gender Equality Targets Bill. My name is Dr. Leonora Risse. I am an Associate Professor in Economics at the University of Canberra. May I take the opportunity to reiterate that I am appearing here in my independent capacity as an academic researcher, and the views and statements that I share should not be attributed to any of my institutional affiliations. I join you today from the lands of the Yugambeh people on Bungalang country. By way of an opening statement, I have offered my submission to the committee from the perspective of collating and bringing together and analysing the available research and compiling these research-based insights to help inform and support the committee's capacity to develop evidence-based policy and legislation. And my assessment is that the growing body of research findings in this space points towards supporting this bill. It would be ignorant of the evidence not to proceed with the bill, which is also an outcome of the extensive review of the Workplace Gender Equality Act that was conducted in 2021. However, I will also add the caveat that I am an economist, and especially as an applied economist with a background in public policy, I also very much understand how this proposal needs to be assessed through the lens of practical application and balancing what we read in the papers against the practical realities of implementation. And we do need to ask, are there risks that could lead to these provisions not working as intended or not being as effective as expected, or triggering distorted, unintended responses or inequities? And I can understand how this type of concern can lead to resistance and hesitancy from some employers. And I think the employer groups are doing their job in raising those concerns. So I respect the concerns that are raised from a legitimate business point of view. But I would also point out, I think there is flexibility within this proposal to accommodate these concerns, including the discretionary decision-making capacity of WGEA. And some examples is the autonomy, the property of autonomy that's within the bill for employers to select the targets that would be meaningful and feasible for them, that represent what is achievable, but also what is ambitious and aspirational for them. Another example, I think, of the flexibility that's offered is this 3-year window to achieve the target and to demonstrate progress. Some of the latest numbers from the WGEA Gender Equality Scorecard report that 45% of all reporting employers are already setting targets. So it means it is feasible, notwithstanding, of course, there are challenges for those employers who aren't already setting targets. And of those who are setting targets, 59% of them are setting targets with respect to reducing their gender pay gap, and other analysis conducted by the Bankwest Curtin Economic Centre has established a statistical, robust link between target setting and narrowing that gender pay gap. But I'd also point out in response to the concerns that have been canvassed that there are a range of targets to choose from. That's the whole point of having a menu. And these span across the various dimensions that all matter and all contribute to gender equality, such as, for example, the usage of flexible work, an expansion in employer-provided paid parental leave above the minimum amount, or an increase in men's usage of parental leave where they are eligible. I would also reiterate, which something I think the committee is well across already, is that this bill is not designed to be implemented in isolation, and that it complements and synergises with the range of other initiatives, resources, guidance, information and policies, both in the public and private sectors, that are all contributing towards change and progress, and learning from each other through those experiences and innovations. And some examples, I would say, are initiatives outside of this bill that are about building that pipeline of prospective employees or board members of the particular gender that is underrepresented. So even though there are some perceived difficulties or challenges with that, this sits within that broader ecosystem of change and initiatives that is happening more broadly. To close, I would also point out that I have canvassed some of these issues in the broad literature review that I wrote for WGEA, and that's also about recognising the importance of building what I've called enabling conditions, like a holistic set of conditions that best equips employers to achieve their targets. And I think some of the concerns that are raised fall into that category. How do you reassure employers that there's going to be an opportunity to readjust in exceptional circumstances, for example, and still support those aspirational goals? And another example that's canvassed in the literature review is the recommendation that targets be set that are proportional. Targets with respect to workforce composition are set that are in a way that's proportional to the composition of the preceding occupational level. So we've got pipeline concerns. We're accommodating that in the design and the statistical calibration of the target itself. I think there's perhaps more discussion to be had about refining potentially some of these targets, how they're articulated, the statistical properties, have they been through, a full set of consultation and robust checking. But on the whole, I would say the bill is really well placed to support Australia to continue to be on the forefront of gender equality in a corporate space. And happy to, of course, address any questions at this point. Thank you.
Thank you very much, Dr. Rees. Can I ask at the outset, you're commissioned by the Workplace Gender Equality Agency to undertake a review of available research and evidence on target setting. Is that review publicly available? And if not, how much of it's canvassed in your other publications?
Thank you, Senator, for inquiring. It is publicly available. It's available on the WGEA website. I believe I did include a link to it in my submission, but it's probably a web link that's buried somewhere down the...
No, I'm scrolling through it now. I think I can
understand.
So the publication titled Gender Setting for Gender Equality, a Review of Literature, is your piece of work that you completed for WGEA independently?
Yes, in full transparency, WGEA approached me. They were looking for an independent piece that was strictly a literature review. So what does the available evidence say about target setting? And the review extended beyond simply do targets work, but what else would WGEA need to know, or what information, what research findings, what research insights, broadly speaking, would WGEA need to know to go ahead with this target setting legislation if it were to come to fruition at that stage. The document that I submitted to WGEA isn't the exact document that you see. I mean, it was sort of a Word document that was also included some messaging for WGEA, as in when you communicate with businesses, what would the research suggest is an effective way, to support the process. And so there was a slight bit of editing, I guess, at the start to make it a more meaningful and purposeful public document. But the essence is there. There were no edits that were done by WGEA without me being fully informed about it, and it was done independently, objectively.
Great, thank you. You mentioned in your statements and have picked up on some of the evidence given by witnesses already about technical refinement of measuring in relation to what's measured and how it's reported. How should WGEA approach developing or enhancing its existing expertise in this regard, noting that its intersection could have regulatory impacts for businesses?
Oh, it is a good question, but it does speak to the need to make sure that all possible sources of input, have been leveraged to design this menu. For clarification, Senator, you're talking about the menu itself, the menu items, or legislation itself?
Well, the Australian Industry Group made some comments about working with the ABS, etc. And I guess I'm wondering what the differences might be in how they gather or interpret or collect data. And
Yes.
So I guess I'm trying to drill down into what the set of issues sitting underneath data and data collection, and how that data is used legitimately.
Yes. Okay. So I also have been involved with some of the preparation work that went towards the articulation of the menu items. The ANU's Global Institute for Women's Leadership, GIWL, GIWL, they were commissioned to work on a piece to provide WGEA with that menu and to explore that very question about how do we arrive at statistics, whether numeric statistics or action-based, action-oriented goals that could be used as a proposed menu. Through the course of that, GIWL did provide me with the opportunity to provide my input and suggestions and feedback into the design of some of those metrics or articulation. So I have contributed I didn't have final discretion over, what was final set of menu items, but I had provided input along that way, along that course of proceedings. I think there is scope for more consultancy into going through each of those potential menu items and just being clear that it's doing what it intends to do from the perspective of employees and businesses. A good example, I would say, is I think there's the example of providing, extending the number of weeks of parental leave, which is clearly an important one on the whole, given that Australia on average has lower average provisions at the moment in the private sector. But that's something where some of the research might suggest you need to nuance that, because there's also research suggesting that too much leave provided to a mother or birth giver can actually be to their workforce continuity. So when it's written broadly like that, what you're also counting on is the employer, with the support of WGEA, to understand what is reasonable and where are they positioned now. If they're positioned at 4 weeks, of course, an increase by virtue of the research and the evidence would support an increase. If they're already at 52 weeks, is another increase actually going to be supportive of gender equality, or is it going to widen existing gender gaps? So there's those types of, I use that as an example, but those types of nuances and refinements that where the research and the evidence, comes into play. I don't think it undoes the whole point of the menu item, but it just means that I think attached to each menu item, there's probably something to be said there about WGEA providing supportive information to say what else do employers need to know about this. When it comes to the statistical, the numbers and how things are calculated, the ABS clearly does already collate, measure things like the gender pay gap and women's representation or gender representation across a range of indicators. And I think over time, more and more information and transparency is available. The ABS has a web page dedicated to explaining the gender pay gap based on its own indicators, and it has acknowledged how the WGEA employer census data is a slightly different scope, a different cohort of businesses, and therefore there's that difference there. But I think WGEA, I have seen WGEA reach out to invite that statistical data analytic knowledge where it feels that it doesn't have it in-house completely. So I would imagine it would continue to do that.
I don't know if you've come across this in the course of your research, but I presume the ABS might get some of its data from tax office. I guess I'm interested in what you may have come across as far as, in terms of making the targets meaningful, the most efficient ways of supporting organisations to collect data and report and draw on other sources of information at the same time as that not being something that takes their focus away. Because if they don't have to do the job themselves to collect that data, then you don't have you're not running your own eye over it and going, oh, look at this, that and the other. But equally, the regulatory burden could be reduced by supporting organisations to, draw on their payroll data from the ATO. What can you tell us about what's happening in that space currently?
Yes. So that very issue was canvassed by the review in 2021, and an exact prompt question in the review was, would you recommend a conversion or a switch to single touch payroll data sources in place of employers reporting it through the employer census? My own view on that was no, because what you have through the existing data collection infrastructure that employers have built and is feeding into WGEA is a very, very valuable data set that goes all the way back to 2012. So we can use it to understand progress over time, what has stalled or impeded progress, what has helped accelerate it. When you have a big change in the way that data is collected, you lose that continuity. And there were various reasons as to why that single touch payroll data would not be guaranteed to be comparable to the way that employers currently report to WGEA. So the decision out of that review, my understanding was that it wasn't endorsed. I think also when employers report to WGEA, they have the whole spreadsheet of their employee database, right? So they have the earnings, their wage and salary, but they also have the other information about them, such as, how many years they've been in that role or other demographic characteristics. So it's better for that wage data to sit in that package of data for it to be made use of, so you can see, where do we have these gaps in our gender workforce. If you start to split up that data, I guess you lose some of that insight and some of that power. And I think most of all what you alluded to is that by devolving that responsibility from employers, it loses the power of salience and the awareness and the consciousness that employers have when they have to,
look at their own data.
Exactly. And I think too, WGEA does establish these points of communication and feedback and correspondence with employers. So, they have these conversations to find out, what are you doing, what's happening. So it is about WGEA building that connection with employers as that centre touch point, rather than looping in through the administration system. Your point, though, also goes to, are we not overloading in terms of regulatory burden? And existing data structure infrastructure has already been set up. So, employers already have to invest. In some ways, it's not adding any more in terms of data collection needs. It's actually leveraging, getting greater usage or mileage out of the data that they're collecting.
It's been raised with us that smaller employers are left out and that the threshold should be changed. Can I ask you how we can use those non-WGEA sources of data where that information's not being captured? So for if it's the ATO or the ABS, we are still tracking the gender pay gap as a whole. How do the two sets of data line up, and how meaningfully can we track what's happening in those smaller employment settings and whether they're going backwards, for example, compared to the cohort that are included here?
Great question, because this is about, what are the reasonable thresholds, and if we squeeze certain segments out of the picture, do they get left out of progress? So we have to keep in mind that employers with 100 or more employees are already required to report. So WGEA does have that data already from those employers, 100 or more employees. It's just this bill
500 is the threshold for picking a target. Yeah, great.
Exactly that. I would also highlight there is nothing stopping those employers from voluntarily setting targets and reporting on targets. This is about, are they mandated to? So within that 100 to 500 employee employee size, you still have employers who are engaged with WGEA, required to report. Right. WGEA has all their data. So we're still following their gender pay gap in terms of what they report to WGEA. So that's still part of the picture, part of the statistical picture. If we're thinking about firms, organisations that are below 100, So I did work on a piece of work on this for the Victorian government, which were specifically looking at how does the Victorian government support and engage small to medium enterprises of that size to engage in gender equality initiatives, and that's where some of those operating, the feasibility is just so variable, and you can't impose an across the board mandate on organisations which operate at such a small scale that many don't have an HR department, many don't have the resources to be able to measure their gender pay gap, and their size is so small that the variation. So if you look at, you've added one more female to your workplace.
It's not meaningful in it.
It can look really large or really small. So there's all those types of things, but there's other ways, obviously, to support that cohort of the business space, and incredibly important. I think that small and medium businesses aren't squeezed out of this overall picture. So there's things, like incentives and rewards and recognition. In terms of data, so ABS will have the overall gender pay gap data measured in terms of earnings. That's collected through their labour force survey every 6 months. And that is across the board, public and private, all business sizes. So that feeds into the ABS statistics, those small.
And where do they get their data from? I know they pick entities or individuals to do that. Do they cross-reference that with the ATO or other sources, or does that break down? That would interfere with the meaningfulness of it?
Yeah, this is something I would recommend consulting with the ABS statisticians to see that how it works. But the main source of gender pay gap data is the average weekly earnings, AWE, which comes out of the labour force survey. So that's just a sample that's conducted monthly or quarterly. And they compute that gender pay gap at a real disaggregated level every 6 months. There are other data sources, the employee earnings and hours, EEH, and characteristics of employment. So they're surveys where the ABS would be going out and surveying employees or employers. In terms of connecting it to the tax data, so this is where the ABS is really advancing. There's PLIDA, there's these ways of linking administration data with administration data with existing ABS data sources as well. So I would recommend, maybe inquiring with the ABS as to how that can continue to be tracked in terms of the gender pay gap or other gender equality indicators in a way that allows us to cross-cut by organisation size and by industry and these other things, other dimensions that mean that, this particular cohort of the business or workforce space is not part of the WGEA picture, and how it harmonises with WGEA. It's a space that's actually really developed a lot in the last couple of years in terms of all the data linkages and administration.
It has, and I'm excited about it too, Dr. Rees. Can I ask, in the context of, sorry, I've just forgotten my question, but I want to ask you about the economy and whether it's the target that will drive things, but other than the target and a company seeking to reach that, what else is happening in labour dynamics that is impacting on this? For example, once you start to see a particular sector snowball in its participation, then it will start to happen more naturally without targets. What kind of things might we observe across the economy when it comes to this gap and labour participation?
Yeah, well, that's a huge question. I think one clear takeaway from the research evidence is that workplace culture changes when you reach a critical mass. And range of research, they've generally found that it's around about that 1/3 share in terms of workforce composition where you really start to see meaningful change. So, for example, if women are underrepresented at boards, you can see the ASX had a target that was set at 30%, and they reached 30% and it kind of plateaued there, which goes to the importance of setting targets. But the 30% didn't come out of nowhere. It's well established by the research that to bring about substantial change and to change the cultures that really mean we're not still hindered by, this is the way it's always been done and it's more inclusive and diverse. It really is about building that critical mass. So you do have still, big portions of the workforce that are still highly gender segregated. We're all familiar with those types of industries, those occupations. So I think, targeting some of those still heavily gender segregated fields is still a matter of cultural change and still bringing about and changing the way things are done, the timing of the day that meetings are done, and ensuring when women go into construction and trade sites, for example, they're not the only woman on the job or on the site, that there's a critical mass there, because that can be, okay, now we will have female toilets and we will invest in female specific uniforms and so I think that's a big sort of takeaway of really what cuts through. Otherwise, it's still so incremental. To the economy, I mean, a lot of it is the job growth in, say, tech and IT. IT is still incredibly male dominated and concentrated. And then, of course, we've got the caring sectors. So really for us to achieve gender equality across the workforce, it really is going to take not just more women getting into IT, but more men getting into care, because otherwise you're going to have the women leaving the care sector to go into IT, and they're leaving a hole where we still need workers, right? So it's about across the board cultural change and breaking down the gender affiliations that we have, that's women's work or that's men's work, and leadership and imagery at a top level, in terms of the way an occupation is presented in the media or culture. I feel like it's a very wide-ranging question.
Yes, it is. For an even more wide-ranging question, it can't help but be noted that the US has a president who's seeking to wind back gender equity measures. It's been raised in evidence here about the idea of backlash and the extent to which we might see that or have seen that, what have you got any observations about that in terms of really demonstrating the overall public good and public benefit that comes from measures like this that takes everybody with them? And how do we demonstrate that so that we don't get caught up in the messaging and politics and can focus on, and cultural politics, and can rather focus on evidence and wellbeing?
Oh, very sharp observation about, the current cultural pendulum swinging in different ways. And we certainly have isolated cases, whether at an individual level, at a workplace level, at an industry level, where pushback, resistance, backlash is very real. And so I have looked at the evidence on that, and it's there's a little section in the literature review about it if you're curious to.
I will have a look.
Yes, but I think the technique that's been used, I think, for the past decade is to try to assert the business case in dollar terms, to say, let's bring more women in, it's good for profits, it's good for innovation, creativity that's going to drive up your business outputs. And there is some research out there that has found that statistical link. But there's not good evidence that that is actually convincing enough, or that it actually doesn't prompt backlash and a backfire, because you're basically saying, let's bring the women in. They're the ones that are driving the profit. How is that going to make males in the organisation feel? They're the ones that are the ones dragging down the profit effectively. So that technique of putting a dollar value on financial return, it certainly will work in some settings. It might be enough to convince some people to, change the dial, push the dial, but there's not a lot of strong evidence that it's consistently enough to convince people's real, authentic, intrinsic motivation. Where I think there's a missing gap that's being increasingly filled now is articulating the case for gender equality through the eyes of how males are not being well served by existing gender norms.
Yes.
How fathers and males are squeezed out of caregiving, how if a male puts his hand up to say, I would like to take parental leave, he's more likely not to have his request supported or to face stigma, made fun of by his mates. I'm generalising, but on the whole, that's what research points towards, where we've done a lot to legitimise we need more women in the workforce as well as caring, because we need the workforce numbers and that educated workforce as women become more educated. But we haven't done the same to normalise men's roles across work and home and community life. And there is really disturbing evidence that men who ascribe more to traditional norms about trying to be tough and brave and not show emotion or not show fear and vulnerability have a higher rate of male suicide, mental health problems, depression. So that's a real piece of wellbeing evidence that we haven't really brought into the fold here. Where does it take us in terms of workplace gender equality? I think there is something to be said there about articulating that when men step into caregiving or spend more time in community work and not necessarily going for the top promotion above all else, is still an achievement. It's still something that fits within masculinized ideals of achievement and fulfillment. And it's not letting anyone down, or it's not falling short of what it is to be a man. Australia still has really strong, cultural norms about male breadwinning and males being the head of the household. It's understandable because people look for a role, they look for a social identity. And for some people and some cultures and industry cultures, gender equality initiatives are seen as a threat that takes away that opportunity for men to fulfil the identity that society has carved out for them, but not replacing it with something that's equally as
meaningful,
or seen as a success. So that's where I've often arrived at, by layering through a lot of this economics, but also the sociology and psychology behind it. If that messaging is there, and that's why I think having targets and menu items that talk about improving where men are currently underrepresented needs to be positioned as healthy and good for the company. It's good for well-being, it's good for productivity, because it means it's good for mental health.
It's lowering the divorce rate, Yeah.
Yes, it's such a thing, yeah. And it's enabling more women to be more attached to the workforce as well. So it's holistic, but we haven't done, that's not a clear messaging that we see or hear across workplaces or, governments even.
So that is something, for example, that WGEA, in terms of men's wellbeing in this context and connection with family, etc., could it be there in the data, is something that we could look to highlight. And there's certainly organisations like Mates in Construction and others that highlight those cultural issues for men around help seeking and, and masculine identities, where they're juggling a lot in being all things to all people without that flexibility that they may need.
Yes, I'm sorry, just to add to that, Senator, I think like the construction and trades industry, I'm aware that Senator Colbeck has a background in that. I mean, that's where I think there's so much to be said about investing in more opportunities for men to feel supported. There's a high incidence of risk taking, safety breaches, because men are concerned about reaching out for help, or not to generalize, but that's the type of real on the ground day-to-day experiences that all add up to the overall.
It is there in the research and the data. Yeah,
it is. It absolutely is.
Senator Colbeck, I'll come to you for questions now.
Thanks, Chair. Look, and thank you. That's really interesting evidence with respect to the conversation you're just having about the balance across the various, I like your term, your gender-separated workplaces, because it actually requires application across all of those things to provide that broader balance and actually get to the numbers that we're seeking as a part of the broader discussion in relation to this particular matter, because it's not just one side of the equation that that drives this. I was interested in your comment with respect to, I think you said the limited amount of economic research that sits there in relation to the value of achieving the targets here. What more might you see would be useful in that sense?
Oh, thank you, Senator, for the question. May I clarify what point you're referring to there? Was that when I talked about the limited research about the business case?
Yeah, the business case. Because I think, that's how a lot of people see or look at this, and there's discussion about the cost to business of the red tape to undertake this process. Sorry, but there's not a lot of conversation on the other side about the business case to do it.
Yes.
Return to the business, if you like, therefore the economy, which is an important part of the conversation.
Yes. So my read of the evidence and the research is that I think traditionally what the research has focused on is if we increase more women in a firm, in an organisation or an industry, we're looking at profit. So often the business outcome was defined in dollar values, profitability, and quite limited to that. And that overshadows perhaps a more holistic yeah, exactly, or sort of other dimensions. Where that research then sort of looked at was the value of having diversity and how that is a feeder for innovation, creative problem solving, more robust decision making internally within an organisation. So you don't have what we would call homogenous thinking, where everyone's got the same background, they all think the same way. It's why you have diversity of committees. And so I think that research was still really continues to flourish, and it does point towards, in a lot of circumstances, that is substantiated. Where the research falls down is saying if you present that to an organisation, that's enough for them to really believe in DEI. And so Senator Pratt's question was about when we see the cultural change in America at the moment and the tech bros and undoing that. Imagine saying to Elon Musk or a hypothetical, a male CEO who's already highly successful. What you need is more women to improve your profitability, because it's not part of their equation. They already feel profitable enough or successful enough. So there's not strong evidence that simply by putting forward that research piece, that's going to change businesses' outlook and change their opinion that DEI is actually valuable and important. It's seen more still as, bringing in people who can add to our organisation, but they don't see anything wrong or faulty about their existing system that needs fixing or needs adding to. So I think that's where you get this disconnect between the research having an impact in bringing about change and a change of persuasion. There's also interesting research on, what is an external motivator and what's an intrinsic motivator. So if people authentically believe, if they've experienced inequality or they've witnessed their family members go through discrimination, generally they're more convinced and believe in the need for interventions or targets than if they've sort of been sheltered from being exposed to those types of experiences. So people can form very firm views of the interpretation of the evidence when it intersects with their own personal realities.
Yeah. You talked at the outset about the practicalities of the implementation and the work that you've done in that sense. The evidence we had from AI Group around a review process inserted into the way that the legislation operates, so that an organisation sets its 3 years target, an event of some sort or something occurs, the capacity to review that without experiencing a circumstance, well, you set the target, you should meet it, and there's a penalty at the end of if you're not. But and it's put in the terms of a reasonable excuse or a reasonable reason, if you like, to review that as a part of the way that this mechanism actually works. What's your thoughts on that?
I'm aware that is a process that applies to the Victorian government's current operation of the Commission for Gender Equality in the Public Sector, and I believe you have the Commissioner, Dr. Nikki Vincent, appearing as a witness later, and who could speak on that as well. So I am aware that process does exist, where not necessarily in relation to target setting, but in relation to demonstrating progress, which as it applies to the Victorian Gender Equality Act, there are provisions for the Commission to consider a defined entity explaining that they've had circumstances that has impeded their capacity to make progress, and to be transparent and report that. And then it's up to the Commissioner to interpret that and to judge what is a reasonable, what is non-reasonable. And I think in this case, it's going to be something, the threshold might be something like what was a factor that you could internally control and what was an external factor that was a big crash in the exchange rate, for example, something external that you couldn't control. And I would really hope that the way that WGEA operates, and I would have great faith in the way that WGEA operates, that they will be reasonable if that was to be considered as part of the provisions. And the upside could be that it gives employers more scope to set more aspirational and ambitious targets, because they know that if something doesn't go to plan, there is a way to explain it without it being an excuse. But if you don't have that, I guess potentially they could pull back and be more hesitant in the target that they set, because they're more cautious about what the ramifications could be, or they're more sensitive to the risk factors that can mean that target itself is more volatile. So I guess you could justify that overall it's supporting the ultimate goal, which is the acceleration of change and building momentum, and you're providing that reassurance for employers to to know that they can explain things and therefore set more ambitious targets. I think on the other hand too, it's important to realise that you do have this scope of menu items. So if you were an employer, hypothetically, and you were really risk aware, there was a particular dimension of the gender equality indicators which you knew was highly volatile depending on your procurement opportunities or your ups and downs of the economy, then perhaps you just don't choose that particular menu item, target. You choose the other targets that are still ambitious and important and is something that you feel that is not as subject to external factors. I think that's part of the point of having that range to choose from, that you can choose the ones that where you aren't, you're more confident about, achieving, but are still equally as important and aspirational and ambitious.
It is a bit, though, in that sense, toning down the aspiration in that sense, if that's the path that you're looking to take, because of your concern about the capacity for the system to move with you, and potentially leads to, okay, let's pick the less risky, less aspirational element of this if we don't have the capacity to work with the system to do the things that we might see that might be a benefit, if you want to put it that way. And just on from that, the conversation that we had in relation to sort of those that have been much more progressive in the way that they've operated, they've achieved a lot more. And I put it in the context of it's sometimes harder to achieve the last yard than it is the first, 99 or whatever, or the low-hanging fruit will gain you so much. The other stuff becomes more difficult. And so the capacity to recognise past achievement within the system and the flexibility for that.
Yes, I heard that come up, and I think it makes sense that could be a concern, and some employers might feel like they're not given due credit for what they have achieved. I would say it's probably very rare that there is an employer out there that feels like they've reached their ideal gender equality outcomes. There's always scope for more improvement, and the whole point of this target setting is to continue to push momentum. So if you are an employer who's already achieved progress and is one of the leaders, I guess, rather than one of the laggards, there are still dimensions of gender equality. If you look across those gender equality indicators, where there is still gaps and not complete fulfilment, and there's opportunity to keep improving in other dimensions. So I would be surprised if there was an organisation out there that couldn't find a target that it hadn't already achieved. And I think the messaging there is it's not about the size. So if a 1% increase when you're already at a very high threshold is still important compared to a 5% increase when you're still at a very low base. They was actually some of the statistical issues that I thought about when I provided some of my input to Jewel. You do have statistical ways to convert percentage increases into comparable amounts, depending on if you're talking about a very low or very high number. There are statistical ways that you can adjust for that. So you're still giving due credit to, a small percentage gain at a high level can still count for something compared to relatively big ones. I think that's things that can be accommodated by the system, and I wouldn't want for employers to feel that they've already. I wouldn't want for the system to make employers feel like there's still no opportunity for progress. And the whole point is for them to be comparing themselves to their past performances rather than comparing themselves to other organisations. So they're comparing.
They don't necessarily always control that. I mean, people look at your numbers and instinctively compare you to others, and you've made a 5% gain, you've made a 30% gain. Isn't that fantastic? But your 30% gain might have been much less substantial in the context of the effort that you might have needed to put in to get the 5.
I think that's why you need like the dashboard of indicators. So we had companies that improved their gender equality gap but came off a really wide starting point, then that's understood in context. We had with the pay transparency releasing some of the gender pay gap as of last year, there were some organisations that had very high gender pay gaps. So their level of their gender pay gap is at the worst end. But if we now look ahead to see, are they going to improve that gender pay gap? That's the measure of progress ultimately. So I think both of those numbers, the level, say the existing gender pay gap, and the rate of progress need to be positioned and understood and interpreted side by side.
Okay. All right. Thanks, Chair.
Thank you. Thank you, Dr. Rees, for your worthwhile evidence today. We're now moving to our next bracket of witnesses who I believe are at the table, and that's the Commission for Gender Equality in the Public Sector Victoria, the Partnership Centre for Gender Equality Leadership Advancement, Science in Australia, Gender Equity SAGE, and the Diversity Council of Australia. For the Hansard record, I'd now invite you to please state your full names of the capacity in which you appear, and we'll start with the Commission for Gender Equality in the Public Sector.
Thank you, Senator. I'm Dr. Nikki Vincent. I'm speaking to you from Wurundjeri land today and pay my respects to Elders past and present. I am Victoria's first Public Sector Gender Equality Commissioner. I was appointed in 2020 for a 4-year term and reappointed for a second term in 2024 to oversee the implementation of the Gender Equality Act. And I play a key leadership role in promoting gender equality in the Victorian community and workplaces.
Thank you. We'll now Partnership Centre for Gender Equality and Leadership Advancement.
Thank you. My name is Professor Helena Teed. I'm the Professor of Women's Health and Equality at Monash University and the Director of the Partnership Centre for Gender Equality and Leadership Advancement. And I would like to acknowledge on behalf of ourselves and our 29 partners to pay respects to our elders and traditional owners on the campuses on which we stand. I, along with our partners, lead a body of research that's relevant to this work.
Thank you. Sage.
Hello, Janine Bredehoeft, Dr. Janine Bredehoeft, CEO of Science Australia Gender Equity SAGE, and I too would like to acknowledge the lands on which I am today, the Ngunnawal and the Ngurrindjeri people.
And the Diversity Council of Australia.
Hi, I'm Chris Lamb, Interim Chief Executive Officer and Deputy Chair of Diversity Council Australia. I'm joining from Gadigal land today. DCA is an independent, not-for-profit peak body leading diversity and inclusion in the workplace. We currently have over 1,300 members, including many of Australia's largest employers. Combined, our members employ approximately 2 million people in Australia.
Thank you. Please make short opening statements and we'll go to questions. We'll do that in the same order if that's okay.
Thank you. I want to start by way of background by describing Victoria's Gender Equality Act 2020, which I implement and which has relevance to the hearing today. The objectives of the Act are to improve workplace gender equality across the Victorian public sector, universities and local councils with 50 or more employees. And in Victoria, this represents approximately 12% of the workforce, and to embed gender equitable outcomes in the community by applying a gender lens to all policies, programs and services that have a direct and significant impact on the public. Under the Act, duty holders are required to prepare a gender equality action plan every 4 years, which involves conducting and using the results of a workplace gender audit to assess the state and nature of gender inequality within the organisation across 7 key indicators. In consultation with their staff, with their governing bodies and with relevant employee representatives such as unions, they must then develop strategies and measures as required by the Act to make reasonable and material progress on the 7 key indicators in every 2-year period. The indicators are largely in alignment with those in the Workplace Gender Equality Act, with the exception that ours also include recruitment and promotion practices and gendered segregation in the workplace. Duty holders also have to prepare a report every 2 years to demonstrate their progress on each of those 7 indicators. And duty holders must also put a gender lens, as I said, when developing any policies, programs and services with direct and significant impacts on the public. And they also report those to me every 2 years in their progress reports. Every duty holder has to publish their plans and progress reports on their own public website, and I also publish all their progress, their data, their plans and their progress reports on my office's website. So on the website of my office, anyone can see the data that shows where each of these individual organisations stand on each of the indicators, the progress that they have or haven't made, and can compare them to others in the same industry and to the sector as a whole. And they can also see what each organisation has committed to do about this in their plans and progress reports. That focus on transparency is designed to drive real progress on gender equality, both in organisations covered by the Act and beyond, by really holding organisation leaders accountable for material progress, creating competitive pressure between organisations on that progress, and also building trust between government organisations and the public by allowing equal access to data and information about the state and nature of gender equality in public sector organisations, councils and universities. And it also helps facilitate knowledge sharing and innovation across organisations. And in addition to the positive change that's been driven by that transparency, as Commissioner, I also have really strong powers to enforce compliance under the Act should I need them. The Workplace Gender Equality Amendment Setting Gender Equality Targets Bill is based on the evidence of what works to accelerate gender equality progress. As is the case with the Act that I oversee, it will require organisations, employers to take a data-driven approach to gender equality. It helps them track their progress that they are or maybe are not making, and thus allow a course correction so that they can achieve the tangible change required. Targets do vary in complexity, in recognition that employers vary in maturity and readiness. And this approach ensures flexibility and that those targets can be tailored to the circumstances of each organisation. And that 3-year cycle recognises that time is needed to make progress. It provides employers with the appropriate time to set up the progress processes, the resources and practices to support their gender equality initiatives. WGEA will do a lot of support for employers and help them, providing relevant tools and resources for target setting, supporting them to build the capacity and skills needed to promote gender equality. And the bill obviously also establishes compliance powers, measures, so that if they fail to meet that target or demonstrate progress, they can fail to comply with the Act. But they can also provide a reasonable excuse. And that underscores that change demands both commitment and sustained effort. As I said, and I put in this in my submission, I commission research into matters related to the operation of the Gender Equality Act, and some of that research has provided insights that highlight the significant potential of targets and quotas and gives key recommendations for their implementation. We provided that research to the inquiry. The key thrust of the findings is that when executed effectively, targets have the power to transform workplace cultures and drive meaningful change. There was also a really fabulous piece of research done by Amy Rogers as part of a Winston Churchill Fellowship. We also supplied that. And from her observations of international jurisdictions with the best practices, employers are required to take additional steps following their pay gap analysis, and that includes target setting and a whole bunch of other steps as well. I note also the important body of research that WGEA outlined, which I've also read. We know that, like financial and operational targets that all businesses would be familiar with, gender targets are an essential part of managing and improving business performance on gender equality. We know those that implement them make more improvement, make greater improvement, and do so at a faster pace compared to employers without targets. And we know that targets are something that leading employers or employers who are leading on gender equality are already doing. And that is a way that they seek to gain competitive advantage in tight talent markets, particularly in male-dominated sectors. And so when they do that, when employers compete for talent in that way, we see social norms and expectations established and shifting, and that can really influence the performance of an entire industry group. So in summary, I welcome the powerful change that I believe this world-leading target setting scheme to accelerate action on gender equality will, if this bill is passed, bring about. But if it is adopted, I do encourage regular monitoring of the progress of the target scheme and, over time, consideration of improvements to its operation as required and the potential expansion of the target scheme to cover more workplaces and more of the indicators and strengthening the compliance and enforcement actions if needed. Thank you.
Thank you, Dr. Vincent. The Partnership Centre for Gender Equality and Leadership Advancement.
Thank you very much. So just in terms of context, the Partnership Centre is a Monash-led partnership, but it's very much about practical implementation, supporting organisations for gender equity and equality change. We bring together about 30 partners with government, healthcare, industry, employer, training providers, academia and research. In other words, all the organisations that are involved in systems change. We're actually funded by the NHMRC and government, and our partners are more recently DFAT. We include private, public, academic, not-for-profit in both the healthcare sector as well as the health and medical sciences sector. The reason we have a focus on those two sectors is they employ 1 in every 4 Australian women in the workforce, and they touch every Australian woman in terms of healthcare outcomes. But our findings and our research is much more generalised across other sectors as well. The Centre and our partners really are focused on the purpose of accelerating gender equity, which is the processes to deliver equality, as well as diversity, and a focus on advancing women's careers into leadership, not just their representation within the workforce, which is a critically important gap. Essentially, we bring together thought leaders, experts in gender equality, and most importantly for this conversation, and probably a point of difference, is our expertise is in implementation science, how you actually implement evidence into practice, how you deliver organisational change management, how you integrate data analytics, which we've been talking about, benchmarking and data feedback, which is important but in itself not sufficient for implementation and change. Our work also encompasses some of the leading organisations internationally, and we bring those learnings from across our partners as well as internationally to this focus. The other important factor is that we also bring in the Gender Equality Alliance, which brings law, business, economics, gender-based violence, healthcare and health and medical science, IT and engineering. So we bring all those expertise together because this is not a problem that can be solved by one sector. By aligning the values and visions, essentially we work with partners to co-produce and deliver evidence-based interventions that are effective in driving and implementing the act that we're now talking about. So the point of difference here is that we focus on effective change, not just what to do to achieve, for example, specific targets that are set, but also how to do it. So enabling an organisation, a designated organisation, to actually implement successfully. And this has been proven through all forms of implementation, not specifically just in this sector. And we've been working with many partners, including the Victorian Gender Equity Commission and the Science and Gender Equity Agency and the Academy of Health and Medical Sciences and others to ensure that the evidence-based approaches are not just the what, but also the how, not just measuring for accountability, but actually measuring the processes of change. So on behalf of those partners and our centre, we very much strongly support this proposed amendment, as do others. There are a few critical points I will raise that are perhaps that are points of difference from the really important points that have been presented today. So accelerating progress here requires shifting the responsibility from the individual, where it has traditionally sat, to the organisation and the policy change. We all know that's critical, which is why this amendment is important. As I said before, targets and measurement alone are insufficient. The evidence on implementation is we must support organisations. Indeed, those who are struggling the most need the most support. And research shows that evidence-based organisational processes need to take a systems approach, and they do need measurement and accountability, but they also need support. So a couple of key things in this is that we've been funded by government already to compile the evidence about what does work, and that's readily available, and we're happy to support that. We've been funded to develop an organisational change toolkit, which is readily available online, which supports implementation with a range of resources. We've just released a report on towards a national data framework, which basically scoped all of the work that's currently happening internationally and in Australia, including WGEA and the Gender Equity Commission, and highlighted how it aligns to evidence. Also highlighting some of the problems. Intersectionality is very hard to measure, and it's important that we consider that in this broader context. But also one of the critical points of difference here in that body of work, which took 2 years, was that we can measure the outcomes, which is what we're talking about here, and the targets and what we want our organisations to achieve. But there's another way to also measure this, which might overcome many of the shortcomings we've been talking about today, which is to measure the maturity of organisations in the processes of change. So the reason that's critically important is it allows us to put forward a very simple maturity matrix, which has been developed and is evidence-based and comes from our engineering colleagues. By using a maturity matrix that focuses on measuring the processes of change within those designated relevant employers, actually allows us to have learnings where some may fail, as we've talked about today. Aspirational targets allowing for failure. If we're focusing on measuring process measures, not just outcome measures, we may learn quite a significant amount about what it was that went wrong in those processes that then did not deliver the outcomes we're looking for. It also gets around the problem we have at the moment. For example, many of the organisations reporting on the very important Victorian initiative will actually put their outcome measures in, but then they'll submit 500 pages of documents, which might be what we may end up with in this context if we're looking at flexibility and variability. That 500 pages of documents can't be benchmarked, can't be quantified, and is very time-consuming to produce and analyse. But when you use a maturity matrix, and the documents we've provided you with actually support this and explain it, it allows you to quantify processes, it allows you to benchmark processes, and it allows organisations to see what the next step is on the ladder if they're not performing. What do they do next? Just giving them a poor target without giving them that support is critically important. So we do commend that document, and hopefully it's useful. Very few key points to align to the other evidence provision here. I do think, just as Dr. Leona Rizza said, evidence is really important. One quick point on backlash. There is, again, evidence that that's less problematic when we use evidence for the why and the benefit and move away from the emotive politics and focus on the evidence. Australians trust science. The results are out again today, and it would be really good if we could take a scientific and evidence-based approach to this. So in summary, we and our partners unequivocally support this bill. We would like to see a focus on implementation and evidence on how to implement, as well as what we're implementing. And we are very happy to provide the government-funded resources and support that we've already got in any way if that's helpful. Thank you for the opportunity.
Thank you very much for that evidence. I will now move to Sage, and then the DCA can jump in. Thank you.
Thank you, Chair, and thank you for the opportunity to be here today to provide further evidence. SAGE is Australia's leading advocate for equity, diversity and inclusion in the education and research sector. In 2013-14, combined action by the government, the Australian Academy of Science and the Australian Academy of Technology, Sciences and Engineering led to the creation of SAGE. The aim then and now is to support systemic change to Australian higher education research organisations and put them on the pathway to equity, diversity, maturity. Important to stress is that SAGE was founded to address one of the greatest challenges of the higher education sector, as well as Australia overall, which is the highly segregated STEM workforce, which also is one of the workforces that is in high demand in Australia. The workforce data, according to the STEM Monitor, shows that only 15% of women, only 15% of STEM qualified jobs are held by women. Only 23% of senior management and 8% of CEO in STEM qualified industries are women. Only 30% of STEM academic teaching and research staff are women. The reality is that the gender imbalances in senior academic roles, especially in STEM, is persistent. In 2024, the highest academic levels, the professoriate, only 26% are women, and in senior lecturers, only 36% are women in STEM. However, the latest workforce data from the Department of Education shows some progress. Between 2020 and 2024, we've seen a 7.7 percentage point increase in the proportion of women in senior lecturers and a 5.4 percentage point increase in the proportion of women and above lecturer professorial level. These promising results and shifts would not be really captured by the WGA data. WGA data shows the proportion of women in leadership in the higher education or tertiary sector is 48% across the tertiary education sector, and across the 58% of the professionals in the higher tertiary education sector are women, according to WGA data. And professionals would capture lecturers and the professoriate. SAGE subscribing organisations do have a lowest gender pay gap. They have a gender pay gap of 7.9% compared to non-SAGE subscribers who have a gender pay gap of 9.8%. So SAGE drives participants' meaningful change through a holistic institutional approach to equity and diversity. Through evidence-based and impact-focused framework, must be also said through a maturity framework, each institution develops a uniquely customised approach to achieve systemic, structural and cultural change, measured against international benchmarks. Institutions begin with a self-assessment, a tailored action plan, and achieve the Bronze Award, and must demonstrate their movement through cycles of evaluation, action planning, implementation and measurement. SAGE organisations also commit to diversity and inclusion, that a diversity and inclusion is appropriately resourced, that it considers all genders, that they undertake a transparent and rigorous self-assessment, that they take an intersectional approach, and they design initiatives based on institutional data. Because of that, SAGE has been evaluated in the Diversity of STEM review in 2023 by the Department of Industry, Science and Resources, a wholesome STEM program review, and the review recommended to fund SAGE because the evidence shows this framework works. It means that when organisations embark on systemic change processes, it creates cultural change toward workplaces where everyone, regardless of women and men or what gender they are, can thrive and want to stay and work. So we have since received further funding from the department to expand our program further. Now, to the target setting, while we wholesomely support target setting as a powerful tool to progress gender equity and to ensure that our organisations are held accountable, we do fear that these targets might not be meaningful enough for our organisations who, as I've told you before, have had nuanced issues in their organisations that might not be visible. And that might mean that such systemic change, such as changing promotion system, building a sustained pipeline for STEM, and cultural change would be overlooked and not be recognised. Therefore, we recommend that the target scheme sort of encourages organisations to dig deeper and get a nuanced approach. For example, we ask the procurement principles that currently do not apply to government grants be expanded to government grants. This is because our sector, the higher education sector, does not rely on the procurement principles. They are really applying for Commonwealth grants, such as the Australian Research Council. This financial lever will be a strong incentive for the sector to continue to invest in their EDA journey, even in a nuanced further way. For further, also, we recommend that WGA partner with organisations like SAGE, ACON and other organisations that work in spaces that really contribute to people with intersectional inequalities. So this would provide a nuanced approach and could be used to help this organisation not to fall backwards. And with regards to resources, we note that our research has shown that our organisations are scared that resources will be taken away. Traditionally, the higher education sector is well resourced in terms of equity and inclusion teams for students due to the government long-standing commitment to participation of people from low socioeconomic background, for example. Perhaps with further alignment of government incentives in this area, there would be a greater incentive for organisations to resource diversity and inclusion, to continue to research these for workplaces and not only for students. And governments could stress the importance of resources in the implementation of policies and practices. Thank you.
Thank you. The Diversity Council.
Thank you. As I mentioned, we have 1,357 members. We work with those members on all aspects of diversity and inclusion in their workplace. One point to note, though, is that gender equality is really the only consistent area of diversity and inclusion that we work with across all of those members, and that's largely due to the fact that there are reporting requirements to WGEA. So we strongly support the passage of this amendment and recognise that critical role that WGEA plays in supporting organisations in their gender equality work. I would also say that we support the recommendation made by the Migrant Workers Centre to prioritise the collection and analysis of intersectional data. We believe that through WGEA, the government should make it a priority to progress gender equality for all women. We do know from our member experience that many businesses currently lack the capacity to collect intersectional data, so this would need to be considered. One of the things we like particularly about this scheme is that it doesn't pose a significant additional regulatory burden, and it has flexibility allowing businesses to set their own targets. We do appreciate that some of the submissions you received identified that it could be extended to employers with 100 people or more. We do know from our member experience, though, that many of those smaller businesses may struggle to comply with this regulatory burden, and we think that focusing on larger organisations with 500 or more employees makes good sense in the first instance, but would obviously support reviewing that after 2 years to see if that can be expanded. I think any more than that, and I will be repeating points that others have made, so I might leave it there and leave the committee to ask some questions.
Thank you. Senator Colbeck or Senator Waters, who would like to jump in first? Senator Waters, please go ahead.
I'd be for Rich to go first, but I do have questions.
Senator Colbeck.
Thanks. Look, just a couple of quick ones. To Commissioner Vincent, Dr. Vincent, I was talking to previous witnesses about the reasonable excuse provisions, and I think it was Dr. Rissa was talking about the way that your system operates and how that works in an operational sense. I'm just interested if you could talk us through that and how that might apply to what's been raised as something that could or should be incorporated into the way that this program might work.
Yes, certainly. So under the Gender Equality Act, each duty holder must make reasonable and material progress, as I said, on those 7 key indicators, all 7 in every 2-year period. But the legislation does allow or does require me as Commissioner to take into account the size of the organisation, including their number of employees, bearing in mind that duty holders under the Gender Equality Act are 50 or more employers. So we do have some fairly small organisations that are covered by the legislation. So taking the size and the number of employees into account, the nature and circumstances of the duty holder, including any particular barriers that they've identified to making progress, other requirements that have applied under any other act that they can raise with me, their resources and their particular operational priorities and competing operational obligations, and the practicality and the cost to the duty holder of making progress. So, and also considering genuine attempts made by the duty holder to actually make progress. So a complex set of factors that need to be taken into consideration when I'm judging whether reasonable and material progress has been made. Now, we're very new in all of this, so we've only had one set of progress data and progress reports that came in towards the beginning of last year. So we've only had the experience of looking at and assessing progress on one set of data and progress reports at this stage. Many organisations did not take up the opportunity to use the part of the template, the progress reporting template that allowed them to describe factors that needed to be taken into consideration. Where they did use that, they tended to stress that they'd made genuine attempts, even though they may not have made numerical progress as such. And some organisations that were affected by fires or major flooding, as was experienced in some regional areas of Victoria, identified those things as well.
Okay. I mean, we've talked about some of the, let's call it supply chain of workforce issues that come in there, and, you know, the efforts that SAGE, for example, are making in the context of building and developing that part of workforce supply. How do those factors get incorporated into the broader process? And that comes from both sides of the equation. I mean, it's preparedness to take up, and we've talked earlier in the day about gender-separated sectors on both sides of the equation, both those that are female-dominant and male-dominant, and even where the thresholds are where there starts to be a level of normalisation once you get, say, over 30% people in a workforce that starts to drive a cultural change in the way people think about it.
Well, I absolutely agree with that, that you know, there is a sort of, you know, there can be a snowball effect seen. But referring to a question that you asked earlier, Senator Colbeck, I think the scenario was raised where an organisation might seek to increase its pipeline of women potentially, for example, in an engineering organisation by bringing in a whole bunch of new recruits at junior level, which would then increase its pay gap temporarily as those women start at the lower level. That is exactly the kind of circumstance that, as Commissioner, I would be considering. So, and in fact, I had numerous examples where organisations said, we have done just that, and that's increased our pay gap, and this is why. And so that was fine. That's a reasonable explanation as far as I'm concerned. And I think you can find similar explanations for the other indicators as well as to why progress in a numerical sense might not have been made. But this legislation, this bill, actually allows for that because it has numerical targets and it also has action targets. So where an organisation feels like it might not be able to achieve a numerical target, for example, if they want to make progress, they will need to increase their pay gap, you know, potentially for a while they increase the pipeline. They can opt for an action target in some other area, which is simply for them to, you know, institute something that will lay down the groundwork to make change in the future. So I do think there's a lot of options for organisations that are incorporated under this bill.
Okay. So just to follow on from that, the question that's been raised around recognition of progress and the perception, and I'll put it in that context, that this is a sort of a reset and we're starting again, and those businesses that have been more progressive done more, and as I've put it, harder to achieve the last yard than the first 30. How that recognition is supported and maintained through this process.
I would imagine there are a number of ways that could be done. So that would be included in the reporting to WGEA that they have in fact, made a lot of progress, and so they are really focused now on that final bit of extra progress, which is perhaps going to be more difficult to achieve. And thus what they have done is, even though it might not be as big as progress for other organisations, is nevertheless important progress. They might decide to pick a target in another area that is not impacted, but perhaps where they haven't put so much focus. As I think Professor Riz said, there would rarely be an organisation which could say we have nothing more to do in terms of gender equality. So if they feel like they've made a lot of progress already in a particular area, then the logical thing would be for them to either opt for a target that, talks about the progress they've made, but the little bit of extra progress that they want to make, and having that taken into account in their reporting to WGEA, or also to opt for a different target altogether.
Yeah. Senator, if I might just add a quick comment to that. I think that one of the challenges in making significant change like this in an organisation is getting buy-in from the organisation and managing the culture change that's required. So I actually think organisations that have already done lots of good work in this area may not always find it as difficult as we might assume to make that next bit of progress.
Yeah, it becomes a part of operating in the way you do business and therefore the way you think, which goes sort of to my next question, which was to Professor Teed in relation to the maturity of processes, which I thought was really quite interesting work and valuable work in supporting businesses in the fact that the reality of being human means things go pear-shaped. Things going pear-shaped is not always a bad thing. You learn something from it, but you also, if you're looking at it properly, learn how to fix it, not to do it again. It's a fundamental of a good quality system and the way that a good system works. And how mature are those? Is the work that you're doing and the processes that are being developed to support this that might be utilised as a part of what we're talking about today?
Yeah, so thank you for the question. And it addresses many of the deficiencies that everyone's been talking about here. The intention to have aspirational targets, the safety to fail, the capturing of the learnings, the excuses or challenges that come in there. Instead of having countless pages of documents, that would all be incorporated into that maturity matrix. To answer your question specifically, the maturity matrix is very well established in all range of fields and sectors around measuring organisational capacity for compliance with regulatory context. So it's exactly designed for this. Now, has it ever been applied in gender equality? Yes, but in the context of Australia and in healthcare, and we can provide those examples. And indeed, that's some of the work that we're now doing with the Victorian Gender Equity Commission. So very well grounded on regulatory assessment in other sectors and being applied in this space with some evidence and examples. The tools and resources are already being trialled and we can easily provide a separate presentation or evidence around that. But the concept is relatively simple. And I think that's why this is really important, is that if we only focus on outcomes, the ones that struggle the most, they just don't know what to do next. They get their report to say you're failing legislative requirements, you must do more. And they may be sitting there with any range of challenges at the moment, and it gets pushed down the agenda, even though it's critically important, for example, in Victoria, to respond. They don't know how. So the matrix not only allows them to evaluate process and address the issues we've talked about here, it allows them to quantify it, benchmark it in a single graph. I think the example is in the data framework report we've sent you. But it also demonstrates, if this is our area of deficiency, what do we have to do next and how do we do it, rather than just giving them feedback. And we know audit and feedback in itself is critically important, with accountability, but it's still not going to help them dig their way out. So in summary, very well established in the broader context and has been trialled in this context.
Okay, thank you, Chair.
Senator Waters.
Thanks very much, Chair, and thanks, Senator Colbeck, for letting me go first at the start of the day, so I thought I'd return the favour. I really appreciated all of the discussion so far, and I'm so grateful that you're all doing the work that you're doing in the community, so keep it up and thank you very much. I've got some questions for each of you. Can I start off firstly with the Commissioner? I confess I didn't know much about your role prior to this process, so just a few perhaps basic questions. Am I right that you just cover the public sector? And is that because WGEA had already essentially covered the field, albeit only for 100 plus companies? So it wasn't necessary for the state ledge to cover that also?
To be perfectly frank with you, I was employed once the bill had passed and the legislation was about to come into effect. And so I'm not aware of exactly what was on the minds of the developers of the legislation in that regard. I have made the assumption myself that, in fact, we didn't want to replicate what the Workplace Gender Equality Agency was doing. That also, I think, we have more. You have more control of public sector organisations, but it is the public sector in its broader sense. So it does also incorporate the universities in Victoria, all of the universities in Victoria, and all of local government, all local councils.
Yeah, that's right.
Yeah, there are 79 of them, and they haven't been included in the public sector more generally, typically before. So it is, as I said, it's 12% of the workforce, so it's a good contingent. But I think also it has the capacity to demonstrate what can be done through legislation before potentially then maybe, working towards incorporation of a broader range of organisations in the future. That's certainly not been expressed by the government, but that's something that could be considered. But we work very closely with WGEA anyway.
Yeah. Great, thanks for that clarification. And interesting that your target is so much lower, obviously, than the Commonwealth target of 100 for the reporting, and in the case of this bill, 500 for needing to comply with these menu of targets.
Yes.
Do you, just on the question of targets, and I'm sorry it wasn't clear to me in the time I've had to read your good materials, does your Act actually have targets as such? And if not, do you think it should? And can you reflect on the utility of us seeking with this bill, the government seeking with this bill, to add targets to the federal regime?
Yes. So our Act does not currently require targets in the same way that this bill, if passed, will. However, it requires each organisation to make reasonable and material progress on each of those workplace gender equality indicators in every 2 years, which by, in and of itself, essentially requires organisations to set themselves targets. They must put in place strategies and measures to demonstrate that they have made progress. So it's targets in a different way, and they don't have a choice of menu as organisations covered by this legislation would. They set their own. And the idea is that they will learn from experience about what works, what doesn't work, and why we publish all of that data is that they can see, they can go and seek out, and we publish kind of positive case studies of practical change. We're coming up for review, the legislation is coming up for review next year. Okay. I'll definitely be putting in some recommendations for some tweaking around some of those sorts of things. But I think that the target setting, as it's described in this bill, will be excellent and will really drive progress in some of the same ways that we're seeing it's being driven under the Gender Equality Act.
Great. Well, hopefully the two jurisdictions can learn from each other and improve upwards. I just want to go now to the Partnership Centre. Professor Teed, thanks for all your work, particularly on helping organisations to actually operationalise these sorts of commitments. I think that will be invaluable to many different organisations. I note that one of your comments, which I strongly agree with, is that performance-based policy levers should also be relevant, and you've made the point that compliance should be mandatory before Commonwealth procurement is available, and I'm in strong support of that. And unfortunately, I think the wording that we've got at the moment implies that it will be a consideration whether businesses have complied with both their reporting requirements and now with these targets. But to my mind, it still doesn't say you must do this or you cannot get Commonwealth procurement, Commonwealth contracts. And I also note other witnesses saying they want that expanded to Commonwealth grants also, which we also support. So can you just elaborate on why you think, or if you think that needs to be clarified and strengthened?
Yes, so there is very good evidence that when we know there's accountability, we know there's incentives, that these are very effective in organisations. And if I can just allude back to the very important work from the Gender Equality Commission in Victoria, our CEOs, as leads on our organisations, were reasonably engaged. They were the partners to this initiative and they were quite strongly engaged. When they had a mandatory requirement and they had to have accountability for reporting, the attitude and approach completely changed. It was top of mind for board CEOs who were now saying, well, hang on a minute, help us. CEOs and board chairs, very, very different context, but they still needed assistance. If we can have initiatives such as incentives for requirement for systems change, it becomes very important. I would also link back to the fact, though, that I think, therefore, we have to be very careful about how we're judging progress, and which comes back to not only specifically did they move every one of the metrics in terms of outcomes, because that could introduce perverse incentives. People will be very conservative. They will only focus on things they know are going to work rather than being brave and aspirational. Yeah. So that focus on also making sure that we measure and can assess their contribution, their commitment, their processes, their steps in the journey. Because if we're doing that legitimately and genuinely, then it's much, much easier to actually measure a broader perspective on change and time frames. We all talk about time frames along what if people can't change in that time frame. If you're measuring processes of change, they're quite quick. Introducing policies, introducing processes, and again, they could be captured. They may not change the outcome metric in the short term, but they can be captured and that effort can be assessed. And indeed, SAGE will be able to give you some more evidence on that from some of their fantastic Signet Awards and case studies that have been performed around how putting in processes, whilst they may take time, are really important. So if we could be more holistic in how we measure the commitment and the approach that these organisations are putting in, then I think, to come back to your question, putting in incentives such as you must be working towards these targets either through processes or change specifically in outcomes to be eligible to apply becomes just an even more important incentive, and it is very, very effective. If you want to get a grant and you don't comply, then you don't have the opportunity to apply and be in the game. People will change their behaviour, and we've seen that with granting systems in places like the UK.
Thank you. It sounds very compelling. I'll go to Sage, and forgive me for mispronouncing your surname, but nice to see you again. I recall when you worked for one of the former sex discrimination commissioners and did some marvellous work in that role. So great to see you again. Can you elaborate on your suggestion that the the WGEA procurement rules be extended out to grants as well, in particular to Research Council grants? I thought that was particularly interesting.
Yeah, sure. Thank you. Look, the higher education the higher education and research sector, they primarily interact with the Australian Research Council and other grant funding organisations, not so much with procurement. So we've put a we've previously recommended that the ARC also links their funding to gender equality policies and practices, but also outcomes. And that is because what we see is while the success rate of women and men is largely similar across the ARC grant success rate, we see that women do not apply to the same rate as men. So to encourage the application rate to the number of applications from women and other genders really to go up, we've advocated and strongly suggested that the ARC will link gender equality, diversity outcomes to grants. And this is also based because internationally we have the Horizon program in Europe, for example, does that. They also have an objective with a 50% target that 50% of women in the Horizon Europe-related boards, expert groups and evaluation committees are gender balanced. They do also have the integration of gender dimension into research and innovation content. So it really is dominant that, that gender equity, diversity and inclusion is in every step of the grant funding process.
Yeah, that sounds really positive. Thank you. I've got a broader question now, and then perhaps the Diversity Council, I'll ask you just for general reflections on how you think the bill could be strengthened. But I'm interested just in
getting short of time now, Senator Waters.
Okay, all right, last question. Yeah. I'm interested in if any of you are anticipating any pushback from either the private sector or the public sector about this strengthening, given we've seen the Trump administration come in and then, essentially override the diversity, equality and inclusion measures that had applied to their federal administration. Are you expecting any similar vibe to take hold here in Australia? And if so, how do you suggest we counter that?
Thank you, Senator. Well, I think there is reasonable, there will be isolated cases, as Professor Rissa also said before. For us to counter is that we work for systemic change. We are really looking at making workplaces better for everyone, not just the so-called fixing women. So when programs are designed to, mentoring programs for women and with programs for career programs for women, there is a chance that men see themselves as they would be missing out. And of course, if we say we really want to encourage a systemic approach, that means we encourage, everyone who has caring responsibility to have a better workplace experience, everyone who is in the LGBTQI+, but to have a better work experience, and not focus, too much on only one part, I suppose. So I don't think that from our sector there will be that much backlash. Yeah.
And perhaps if I could just add, as I said before, I think if we focus on evidence-based approaches and the fact that these are evidence-based strategies with evidence-based outcomes and deviate from the politics and the emoji response, very much focus on that perspective, I think we'll get far less pushback as well.
I've got a quick question for the Diversity Council.
Thanks, everyone.
I wanted to ask, please, in the context of, we know this legislation looks at gender equality. However, there are a whole range of attributes in equal opportunity law and also in other pieces of legislation and also in the work of the Diversity Council and other organisations. I wanted to ask you what we might see in WGEA data, for example, that might correlate with other inequalities. So, for example, gender and ethnic background in low-paid occupations, etc., and what kind of uplift we might see in outcomes that gender is just one lens for, because lifting gender becomes important to those other attributes.
Thank you, Senator. I think it raises a great point, and it's one of the reasons that we would really advocate for taking an intersectional view of the data, because we know from our research and research that others have done that women from let's say culturally and racially marginalised backgrounds experience greater difficulties in pursuing careers in certain industries and types of organisations, and we know that other factors also impact that. So really, the more, I guess, if you want to refer to it as dimensions of diversity somebody identifies with, the more those compound and the more those impact their likelihood for career progression, success, etc. So I think if we can work with WGEA and organisations to take a really intersectional view of the data, it will highlight specifically what some of those challenges are, and then we can look at us supporting organisations, other organisations who can provide that support as well to address some of those systemic issues, because gender is part of it, but it's certainly not the whole story.
How useful is the existing data for those other lenses? I'm presuming we don't want to increase, there's effort not to increase the regulatory burden. What depth can be put in more easily, but also where have you got existing data that you can overlay in particular sectors, for example, to highlight those issues?
It's a big question, because I know that organisations don't always capture the data to enable them to even report what that is. So I think data that exists in the market, like the HILDA data, etc., could be used to take a view on some of those things as well. But I think that getting consistency around data definitions and how do you actually define what, for example, cultural diversity looks like, and then how do you measure that and report that, and then working with organisations to make sure that they capture that data so that they can report that. It's not a quick fix, but I think it's an important part of the journey.
Do you expect there might be sectors in which it's hard to get the uplift you expect because gender is not just one of the dominant factors? It might be cultural background or ethnicity. For example, if you work in aged care and health services, just focusing on, will having that gender lens, lift women in those occupations, and where will there be limitations because there hasn't been enough focus on culture?
Well, I can't predict exactly where they'll all be, but I think you identified some of the challenges there in industries and occupations where you have not just a gender disparity, but you have concentrations of people from culturally diverse backgrounds, then that compounds the issue. And I think what we see is in any industry where there are minority groups, whatever that minority is, those individuals struggle to get the same access to opportunities as the majority groups. Now, in many cases, the majority group is men, but not always. Sometimes you're talking about a cultural minority, majority group as well.
Yeah. We are now running a little bit over time, so we're going to suspend for a short break. We were due to have afternoon tea, but if it's okay, we'll just make it a 5-minute break, if I can get a nod from my colleagues, if that's okay. And then we will return with the Law Council. I understand information on parliamentary privilege and protection of witnesses has been provided. I'd now like to ask you please to state your full names and the capacities in which you appear today.
Australia.
Kate Eastman, Chair of the Equal Opportunity Committee of the Law Council of Australia.
Adam Fletcher, Senior Policy Lawyer at the Law Council of Australia.
Thank you. Please make your opening statements.
Thank you, Chair. The Law Council of Australia acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to their elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples present today. The Law Council thanks the committee for the opportunity to provide evidence to this inquiry. We would like to note that given the timing of this inquiry over the holiday period, in-depth consultation with the Law Council's constituent bodies across the country has not been possible. However, subject to the recommendations made in our submission, the Law Council supports the bill and would be pleased to see it pass. Generally speaking, we are pleased to see the evidence-based approach to the design of the legislation as reflected in the explanatory memorandum. Setting binding gender equality targets, we think, will be an important step in strengthening gender equality in workplaces across Australia. Still, there are potentially some serious consequences for business if they're found to be non-compliant with the new regime, and our recommendations are formulated with this in mind. Our recommendations are as follows. We think that an independent review mechanism should be provided for businesses deemed non-compliant before the Workplace Gender Equality Agency can name them publicly in accordance with administrative law principles. We think it would be helpful if reasonable excuse was defined for the purposes of sections 19D and proposed section 17C of the Workplace Gender Equality Act, including a non-exhaustive list of relevant factors to provide clear guidance for businesses seeking to explain their apparent non-compliance. And there should be a provision in the bill for a review after a suitable period to determine whether the targets regime is operating effectively, particularly since this regime is the first of its type anywhere in the world. My colleagues and I would be very happy to answer any questions the committee may have about the Law Council's submission.
Thank you. I'll commence with my first question and then I'll go to colleagues. I'm interested in the intersection of this Act with other law. One of the and the WGEA Act overall. We have anti-discrimination law in Australia that's brought on a case-by-case basis, and yet we can see people, organisations reporting against meeting targets based on gender as an attribute within the Act. And I'm interested in the relationship between the two in terms of how universal how well we uphold anti-discrimination law as in the Sex Discrimination Act specifically overall, and how we see WGEA's work and its reporting as a reflection of that.
And I'm going to immediately pass to my colleague, Ms Eastman.
Thank you, Senator. That's such an interesting question. I'll try to keep my observations brief because this could be a long conversation.
I think it is.
I think historically our Sex Discrimination Act, if I just focus on that legislation, has really had a focus of trying to set standards about what would be appropriate conduct in the workplace. But for the most part, that law has operated as a reactive model. So when something goes wrong or a person has experience of sexual harassment, sex discrimination or some other unlawful type of conduct, then the Act then sets up a mechanism to enable them to make a complaint, and that complaint is then partly resolved through the processes of the Australian Human Rights Commission and perhaps on to a court or tribunal. So it's been very much a reactive model. The work done by the Australian Human Rights Commission in the Respect at Work inquiry into sexual harassment in Australian workplaces really highlighted that we were not making a lot of headway, particularly on sexual harassment, while ever we put the burden on the person who experienced harassment, the victim, to have to be the one to bring forward the issue and to then pursue a complaint either against the person who engaged in the conduct or their employer. So that old model wasn't working in sort of shifting the cultural dial or dealing with the systemic issues around gender inequality in workplaces. So the recommendation coming out of Respect at Work, particularly the recommendation that there be a positive duty reflecting the work done in Victoria for many years in its Equal Opportunity Act, resulted in Section 47C. And this committee, but obviously other committees of this Parliament, have looked very carefully at the operation of Section 47C, which is the positive duty. And that now requires employers and persons conducting businesses and undertaking to look very carefully at the way in which their workplaces operate, have regard to a mix of legislative obligations such as work health and safety obligations, even corporation law obligations, and to think proactively about how do we eliminate such practices in our workplace without placing the burden on a particular individual at a particular time to make a complaint about a particular incident. So some of the amendments to the WGEA legislation have also come out of that broader suite of work done to reform aspects of the Sex Discrimination Act and Section 47C. So for most large businesses in Australia, they are working on their Section 47C obligations. They should be. If they're not, there's an issue there, and perhaps you can ask the Sex Discrimination Commissioner about that because she'll follow us. And the Commission's now got some regulatory functions in that regard. So the gender targets and indicators in the WGEA legislation match extremely well with the 47C obligation, and together I think that they are really starting to change that landscape, and the matters that you've just had with previous witnesses giving evidence just before us have really identified the importance of having devices in law and reporting to ensure that you can start to achieve those cultural changes in Australian workplaces.
Thank you. That's a super helpful answer. Just before I pass to colleagues, can I quickly also ask how discrimination, for example, against women based on whether they've got their period or menstruation, the extent to which you think that kind of discrimination is or is not covered by the Sex Discrimination Act, and therefore should also be seen as part of the uplift that we're looking for in this Act?
It's definitely covered because the way in which the discrimination law operates is on having the characteristic of sex, but a characteristic that appertains to a person of that sex or generally imputed. And for the most part, it's women who have periods, who have menstruation or menopause, and those are being relevant attributes connected to that particular aspect of gender is well and truly covered by the Sex Discrimination Act. But perhaps not a lot of attention is given to that when we look at issues around gender equality and sex discrimination.
Thank you, that was helpful. Senator Waters, Senator Colbeck.
Thanks, Chair. I've got a few questions. Thanks very much to the Law Council for giving us your considered views as you do on so many topics. It's always really appreciated the expertise that you show. I wanted to take you to your suggestion about including labour hire employees in the WGEA reporting regime and in this new bill to expand the requirements out to include seeking to achieve measurable targets. Can you run through if there are any barriers to that from a legal perspective and what you think policy reasons for including that cohort of workers are?
We were considering whether that was appropriate to include, which is why we reserved the position, but we have subsequently considered it further and have decided that it was not appropriate, and that's why we haven't
I see.
I didn't.
Well, are you able to run us through your reasons briefly why, just out of interest's sake?
I might pass to my colleague Adam to go through that.
Yes, thanks, Madam President. We managed to consult after putting in the submission with one of our industrial law experts who pointed out that control over labour hire workforce by a larger company engaging these labour hire workforces is lower than over direct employees. And it could give rise to potential discrimination issues where a business is specifically requiring that another business, the labour hire business, provide employees of a certain gender. Obviously, it might take a bit more working through to develop a complete answer to this, but those are the considerations that have been raised so far. I'd also note that the labour hire businesses might have their own reporting obligations under the WGE Act and other legislation separate to those of the businesses engaging the workers through them.
I think you're probably right. It's not my area of expertise, but I imagine many of them will have more than 100 people on their books and, as you say, would therefore be covered in their own right. Okay, thank you. In your sub, you've recommended including a list of reasonable excuses to be considered by WGEA in determining whether employers are compliant. Can you run us through what you think that should include and why?
It's why their efforts have been unsuccessful. Has it been economic circumstances? Has it been particular circumstances relating to areas of business, or have there been other setbacks in it? It'd be helpful to have some kind of guidance as to the kind of things that the agency would regard as basically an acceptable excuse.
I think, can I add to that? I think partly is for those reporting who've identified a target, be it numeric or action, particularly with action, the question for meeting the target might be, how are our efforts going to be measured? What are the type of factors that WGEA would take into account? And just some guidance so that the efforts to achieve, particularly the action targets, are going to assist both WGEA but also the particular employer, so that you've got some common language and some common understanding about what the approach might be. So reasonable excuse is obviously something that would need to be very carefully looked at, but an employer company would need to have some sense about how that's going to be measured and know that in advance, as opposed to being told that you had not met the threshold of a reasonable excuse and then be subject to that sort of public announcement. So I think that's what
if you've taken misguided steps.
Yeah, we're just concerned not to be so rigid that it removes discretion and flexibility, but to have something that provides some certainty, and that would be consistent with WGEA's obligations to assist companies, and that's part of its legislative mandate as well. So I think that was the context in which we were thinking about that recommendation. Is that
So clarity of understanding then on what's required. Do you think there would be an objective definition of reasonable excuses, or do you think it would be modified depending on the type of industry or the type of employer? And if so, how do you go about defining that in a legislative sense? Or are you saying it would be a non-legislative definition that WGEA would just communicate so that each party was clear on what their obligations were?
I think Mr Fletcher might add to a small comment that I would make is I think there are legislative definitions and concepts in other areas in terms of what reasonable excuse might be, but I think it needs some careful consideration in the context of looking at meeting either a numeric or action target, and they're both going to be different, so that you are always working on continuous improvement rather than a more sort of hard marker that if you haven't achieved some specific standard, then you would need a reasonable excuse. But Mr Fletcher might want to add to our comments.
Thanks, Kate. No, look, I think the only thing I would add is that in our submission, what we suggested might be appropriate is a non-exhaustive list, and we would leave it really to employers and employees, as has been discussed in earlier hearings today, who would know best what kinds of considerations they'd be able to work those out with the WGEA. We're not calling for a very prescriptive approach in the legislation, just more guidance.
Yeah, fair enough. I think that's a reasonable approach to not have it prescriptive in the ledge. And I thought it interesting when you listed off some suggested parameters that many of those factors were outside of the control of that employer, and certainly one can understand that they can't control everything. Thank you. Just probably one final question from me. I noted in your submission that you were, quote, pleased to see no new reporting requirements were being imposed on legal practitioners and their clients. Why was it that you were pleased that these changes wouldn't impact your industry?
Sorry, I just missed the last bit.
I'm just interested in why you were pleased, or why your sub says that you were pleased that you wouldn't have any new reporting requirements for legal practitioners or clients. Why did you see that as a positive?
Well, I think it's more that the very large employers in the legal profession are already doing a great deal of work to ensure that they are meeting the targets that they put in place several years ago and are achieving really good outcomes in making sure that they're getting women into partnership and into senior management positions within the firms. So I think for the legal profession, I think we're not doing too badly in the solicitors branch of the profession. So I thought, my perception is that amongst the large law firms, there is a widespread understanding that diversity and equity and inclusion practices are completely beneficial. They are part of the business case for partnership, and they are part of ensuring that the practices are dynamic and successful.
Oh, I'm pleased to hear that. Certainly when I was in the legal profession some time ago, and this was before pay secrecy clauses were outlawed, which of course I then had a private members bill to outlaw them, which ultimately has become government policy. I was being paid differently to the law graduate who had the same qualifications as me, although I'd gotten better marks than they had. So I'm very pleased as a former lawyer that you say that you think the industry is changing. It certainly needed to. That's good.
I think we made great strides, and in fact, if I can say in my own firm, although I retired from it 6 months ago, we have now at partnership increased to 37% and expect to be at parity within 2 to 3 years.
Oh, good. I certainly hope so. That will benefit that business, as you say, as well as
totally
everywhere. All right, just one final question, if I could. You've mentioned the importance of diversity, equity and inclusion measures as something that you think the legal profession values, which I'm pleased to hear. I'm concerned at the backwards steps that are being taken by the new US administration. Are you concerned that we might see an import of that sort of ideology and that there might be pushback from either the legal sector or any other sector on promoting diversity, equity and inclusion?
Look, I expect that there will be some pushback because it's popularism and in the newspapers and people pick up the mantra. But the fact is that diversity and inclusion policies are about merit, and they're about seeing merit in all of its forms. And it's not, special circumstances or special pleading or any of that. It's about making sure that the most merit-worthy person actually gets the job. And I would be pushing back with my law counsel hat on very strongly against any move in the legal profession to go backwards.
Great. Thanks,
Senator Colbeck.
Thanks, Chair. Just in respect of no extra responsibilities on law firms, and you said that's because you're already doing it. But isn't that the point in relation to this legislation? The businesses that are coming under the purview of this piece of legislation are also already doing it, but are being required to take another step. Is that non-requirement to do it because of the business structures?
Are you speaking just in relation to the legal profession?
Yeah, it's a curiosity question as much as anything else, having sat round the table on the consultants' inquiry that finished last year and looked at business structure as one of the issues that
I see.
we considered, not necessarily coming to a conclusion, partly because of our awareness of your profession, to be frank, but that's the driver of the question.
I don't know what the position is in relation to the management consultants or, the large accounting firms. I know that in relation to the legal profession, there are now a very large number of women graduating from law school and coming into the profession, and if you don't treat them properly, it is just common sense. You will not get the best talent, and you will not retain the best talent out of that pool. Now, I am not certain whether it is more reflective of the makeup of the profession. Do you have any insights on that, Kate?
I think when we've sort of said in our submission that we're glad there's no new regulations on the legal profession, we're not suggesting at all that this proposed legislation and changes will have no effect on the legal profession, or we don't have to do anything. In fact,
because we will keep doing.
We have lots of areas in the legal profession where we really do need to look at sort of systemic structures and practices, and the types of both numeric and action targets that this legislation would develop are going to be materially relevant to particularly large law firms who've got over 500 employees. It gives those law firms an opportunity to build on what they're already doing, but I don't want you to have the impression that we, as a profession, feel we've got nothing more to do.
No, because that's certainly not what I was trying to convey.
That's right. We have a lot to do, and there are many areas where we can improve, and this particular process would certainly help the legal profession identify how it can do more, how it can do better. On these matters, there's no final destination. It's always ongoing and continuous improvement. So I just wanted to make sure that we were not conveying that we had.
It's more that we have the infrastructure in place in the larger law firms, And so we have the infrastructure in place to make sure that we're continually monitoring, making sure there's no gender pay gaps at particular levels, making sure that we're considering all of those kind of issues. I mean, there is work that we can do on transparency and the like. So there's certainly areas to up the game.
Yeah, and look, I mean, it's an interesting conversation. Although you look at Commonwealth Bank, who say they have all of those processes in place too, and that they report a gender pay gap of about 1%. Yet WGEA considers that their pay gap is in the teens, not at 1%, because of the way that they define what the gender pay gap is. So I just thought that was
sorry, I apologise.
I'm not defending the Commonwealth Bank either, by the way.
Oh, no. We would have a disparity between, there are still more men in senior positions than there are women, and so there are still more men at the very, very top who are probably paid a bit more than some women counterparts. But a lot of that is a function of the fact that we've got a lot of younger women now coming through the ranks. And
that would be, as we've discussed earlier in today's hearings, one of those longer term resolution type of matters, as we discussed with engineers earlier in the hearing. But I thought it was a curious response to a colleague's question that we're pleased that we don't have any further.
Oh no, no. It's more that we've got the infrastructure there. Now we just keep building on it.
Well, again, I make the point. Everyone else, a lot of other people would say they have the infrastructure there, but we have processes to ensure that there's visibility into those things. I'll leave that alone now. I just want to go back to the question that Senator Waters asked you in relation to the reasonable excuse elements. Have you had a look at, and I've asked this question of a few others, and was referred to what the Victorian Commission for Gender Equity in the public sector was doing in relation to that and how they operated that sector. We've been pointed to that in some other evidence. I just wondered whether you had a perspective on that, noting what you've already said in relation to how that might work. And I think the importance of a definition so people understand beforehand what they might be able to talk to a GEA about legitimately makes sense. It's a matter of how you manifest it.
Senator, thank you for that question. Unless Mr Fletcher wants to add anything, we have not specifically looked at the Victorian model, although we heard Ms Vinson's evidence earlier today. That is something which I think we can certainly examine on that question. But I'll just ask Mr Fletcher if he wants to add anything.
No, I didn't get time in preparing the submission to study how the Victorian Commission works in practice in terms of dealing with employers' explanations and so on. Sorry.
And the other matter that I've talked about a few times was the recognition of progress. Is there anything in the way that you've looked at the legislation that those more progressive firms who are concerned that the reset of the system or the process that this legislation provides can ensure that their work continues to be acknowledged or recognised as a part of the way forward from here?
I think probably all we could say in answer to that is somewhat anecdotal, and that is that, as the President said, a very significant number of new lawyers coming into the profession are women, the competition for graduates in the large commercial firms is fairly fierce. I can tell you from having young women law students who've worked for me and worked in firms, they actually look at WGEA data, they look at other data available about what firms' policies and practices are in place, the number of women partners. Young women are very interested in understanding the data to get a sense about what type of workplace they're going into. And so while some firms may say that we've already done a lot and we're a very attractive place for women, I think young women will expect more of law firms as time goes on and it shapes their decision making. The second is that our clients, and we are a client-based business, our clients are also very interested in what is happening in our own workplaces, and some of our clients also have some fairly strong views about their expectation of their service providers. So I think the nature of the business that we do as law, being a service industry, is that there's lots of different people who are looking at us, our clients, the pipelines for those who want to enter the profession, and various other bodies that regulate us. And so if there is ongoing improvement and that's recorded in the data that WGEA would release publicly, I think that would be a very beneficial thing, and those who are doing well will be recognised, and those who continue to do well and improve, they will still be recognised. I think this idea that there's a destination point and if you've achieved that then you can stop is something that we are very conscious should not be part of the objective of this legislation. It's not setting an end point, it's ongoing improvement.
I would certainly agree with that, and in particular in relation to employment of new talent, recruitment of new talent. Very often we are interviewed by our young law graduates, and they are very interested in whether I go to this large firm or that large firm, and very, very motivated by the WGEA data.
Okay, thank you. My question wasn't necessarily specifically focused towards legal firms and the Law Council. It was more generic and across the board, and how that recognition might apply to the operation of this piece of legislation. But I think your answer has probably given an indicator there, even though you have put it in the context of where the legal profession sits, because I think women are looking at those attributes when they're making some of their employment choices and decisions. So that the capacity for that recognition of progress but also intent becomes an important part of how all of this is measured. Okay, thanks, Chair.
Thank you. Just one final question from me. Some of the organisations reporting to WGEA have access to the religious exemptions to the Sex Discrimination Act. So as in evidence you've given, the Sex Discrimination Act in taking a case is reactive, but not everyone gets access to that, will be successful, or frankly, they get ruled out of being able to take a case at all. In the meantime, that very same school or institution can say that they are working towards an uplift, or that they have policies, formal strategies on sex-based harassment and discrimination. Should there be a qualifier for organisations that retain a right, or often we don't know? They are given that right by virtue of being a religious organisation, but we don't know if they exercise that right. And so it's hard to interpret what they're actually reporting against based on the reality of what's happening on the ground. So, for example, one of the schools in WGEA's data required staff to affirm that they believe marriage is between a man and a woman. And while that in itself might not be outside the Sex Discrimination Act, discrimination on marital status is, and it's difficult to, we want to be able to see whether we can take at face value what those reporting against WGEA's reporting guidelines is actually what they say it is.
We might have to take that question on notice, Chair, and give that one a little bit more thorough consideration, if that's acceptable.
Yes. I think we've got a short timeline, if I did have an intern write a short paper for me on it, if I can get that to you.
Thank you. Sure. Certainly.
I want to thank very much the Law Council for your evidence today. I found that extremely useful, and I'll now welcome the Australian Human Rights Commission.
Good afternoon. Sorry about that slight hiccup.
I now welcome you to the committee. Are you able, please, to introduce yourself with your name and role and capacity in which you appear?
Certainly. So my name is Anna Cody and I'm the Sex Discrimination Commissioner at the Australian Human Rights Commission.
Please go ahead with an opening statement.
So I'll be very brief in my opening statement, which is very much to reiterate the recommendations that we made in our submission, which supports the introduction of the new Workplace Gender Equality Amendment Setting Gender Equalities Bill, Setting Gender Equality Targets Bill, that we think that the use of targets is a very important step to achieve gender equality, that it is one measure that should be used across Australia. We would submit that rather than it being limited to employers of 500, that it should be inclusive of employers of 100 employees. And also that we recommend that the number of targets be increased so that there be 4 targets, 2 numeric and 2 action targets that an employer would meet over that 3-year reporting period. And then additionally, we would recommend that in addition to reporting on the availability of flexible working arrangements, that we would submit that should also include the uptake of flexible working arrangements to gain an understanding of just how effective it has been as a policy that has been introduced at a particular employer. Finally, we would recommend that the data be inclusive of the specific experiences of workers with disability who are LGBTQI+, First Nations, and also culturally, racially marginalised backgrounds, as we know that the women particularly experience greater disadvantage and inequality, those who are from those particular backgrounds. We are really encouraged to see the introduction of this and have been very interested to see the broad support across all sectors, all stakeholders, including employers, gender equality agencies, as well as trade unions for these measures. Thank you.
Thank you very much. I'm just going to commence with a quick question myself, which I don't know if you were listening to my question to the Law Council, but it's a technical question around the access to the exemptions in the Sex Discrimination Act and the reporting obligations under this, which affirm, if you like, a positive duty in relation to preventing of sex discrimination and harassment. And I am unclear the extent to which those exemptions can be used to opt out of that positive duty, and whether when an organisation is reporting to WGEA, what that means about their relationship with those exemptions.
So I think that the example that you used is perhaps not as useful in terms of a same-sex marriage relationship, because that would be more
probably more divorce and marital status in general, yeah.
Or pregnancy of a single woman, for example.
Yeah.
Yeah, so both of those would be examples where a religious organisation may claim the exemption, that they're not bound by the Sex Discrimination Act because it goes against the teachings of their faith. I think it's an interesting point. I could see that it could, an organisation, because of the choice of numeric and action targets that they comply with. So if they chose to, depending on where they were in that journey towards gender equality, if they had to still introduce a policy, or if they had to introduce a flexible working arrangement for parents at their particular place, their workplace, then I can see how they could completely avoid reporting or discussing whether or not, for example, someone was dismissed because they had become pregnant and were unmarried.
Do you have any insights for us in terms of how we should deal with that? I guess, I would be a supporter of repealing those exemptions, but at a baseline, perhaps we need to collect data on whether a reporting organisation is exempt under the Sex Discrimination Act, and whether they would seek to access that exemption should a case be brought against them. Because if they've got a defence, then they shouldn't need to access the exemption unless they're seeking to explicitly discriminate.
I guess it's the broader. The Australian Human Rights Commission has argued for those exemptions being removed, and I personally have advocated on these issues, and I know that the Commission has advocated over a period of years that those exemptions should be removed. It's difficult because the targets are ultimately used for benefits of government grants, Commonwealth grants, as well as access to procurement for government services. I could see that you could potentially limit, if you extended use of the exemption, to whether or not an organisation should get a grant. But we know that many religious schools do get Commonwealth grants. They all get for education. They all get support for private school funding, for example. So I think that it would perhaps be outside the remit of this to try and put those two issues together. It would be a creative use of this particular piece of legislation.
I'm not sure that education funding is, in this case, necessarily part of what's expected in grants or procurement, as much as I might argue that it should be. I guess I'm reflecting on the lack of transparency around it, because in addition to pregnancy, I've also heard cases of discrimination involving the use of IVF and a range of other attributes that are covered by the Sex Discrimination Act that have been brought up by unions, and nevertheless reporting entities are saying that they seek to uphold the Sex Discrimination Act. And we can never really find out what's going on, because at the first pass, these organisations, when people take these issues to the Human Rights Commission, often they don't get past the first pass because of the exemption.
Yes, that's absolutely correct. And there is a lack of clarity and transparency about how widespread the use of the exemption is. We certainly hear anecdotally and through the complaint service that there is use of it, but in our public advocacy, we would frequently hear that it's not used by religious institutions. So I think it's a difficult one to try and get a grasp of, unless the exemption were removed, and then we would have a clear understanding of just how widespread it had been used.
And what about even just that public-facing side, that a institution be placed on record whether they would ever seek to use that provision, just so that at least there's, if someone does take a case, there's a way of highlighting the fact that it is against what they've put on the public record.
Within this particular amendment, whether or not it could form part of a policy that an employer would introduce, that would be possible. I find it difficult to imagine how you would include that in the legislation itself, other than in the explanatory memorandum, perhaps around including in a policy around employment of staff the intention not to use it.
Yes, and I guess it would be just a declaration that, notwithstanding the reporting in this, we retain the right to use religious exemptions. I guess I can't really see how it could. I could see that it could be impacting the data, or not being, or that kind of discrimination not properly being reflected in the data, where a school, for example, can declare it has got a policy to prevent discrimination and nevertheless might discriminate against someone for being married out of wedlock or using IVF, for example.
And I think legally it would be difficult to be, I could see how hard that would be for someone to actually make a complaint and say, but you've said in your policy that you're not going to be bound. But I think it would, so I'm not sure that would be binding, but in terms of the educative process and function, I could see that could have a purpose.
Thank you. To my colleagues for questions.
Thanks, Senator Waters. Thanks, Chair. I just want to go to your evidence saying that there should be two numeric and two action-based targets set as part of the process, and then going to the, I suppose, the practical elements of the application of that, and evidence that we've heard today and questions that we've had around a definition or some guidelines around what is a reasonable excuse for a business to go back to WGEA and have a conversation around issues they might be having in meeting those targets, and how you might see that operating or being provided in a practical sense, including, as we've been pointed to in previous evidence, the example of what the Victorian Commission for Gender Equality in the public sector does in the practical operation of their requirements in Victoria.
So the rationale for suggesting or submitting that there be two numeric and two action is really a frustration with the slowness of change, that perhaps contrary to the previous Law Council submission about that it's about the number of women entering the legal profession and that only just having increased recently. I would dispute that even though we have had women in many industries for a long time, there still are significant gaps in the achievement of gender equality, and that we know from international research, as referred to in Chief Executive Women's submission as well as the WGEA submission that targets work and that they perform an important role in actually even just the setting of them, regardless of where an employer is in their stage towards gender equality. So it is recognising the need for more urgent, speedier action around gender equality, that we have a very resistant gender pay gap. I am concerned to see that while many employers did decrease their gender pay gap, 44% increased their pay gap over the last reporting period. So actually it's not necessarily an inexorable journey towards gender equality that we are on. And so we need to make clear, committed steps, which is the rationale for the 2 and 2 recommendation in our submission.
So, to the next part of my question, which talks about a reasonable excuse for non-compliance, or a definition for that to be put into the Act from the perspective of the operation of it, and how that might be constituted, and the example which we were given was what happens in Victoria. Just if you had a view on that.
I have read many of the submissions, but I have not read the Victorian one, so I can't give an opinion other than I know that they don't have targets in Victoria, and so I don't support that. I think that having targets is an important measure because I think it does drive change, even if the targets vary. And I think that the way in which this legislation is framed enables for enough flexibility for each employer to meet what stage it is at in terms of that movement towards gender equality. So I think there's enough flexibility in that, and with the reasonable excuse as an additional provision to enable employers of a range of sizes and a range of resources and with differing proportions of women in their industries to be able to meet the targets that would be set out.
So you think that having a definition of a reasonable excuse or some guidelines around what might a reasonable excuse may be in an operational sense would be useful in terms of the operation of the scheme, of the legislation?
I think it may be useful, but I also think that would develop over time as employers made particular arguments. I wouldn't want it to be used as a way to avoid responsibilities. If there were guidelines, they would need to be fairly strictly constrained.
Okay, no, that's fine. That's fine. My next question has been around recognition of progress, and given your comments a moment ago about frustration about recognition, about the pace of change, I'm very happy to acknowledge your comments in asking the question. But there are some employers who have been clearly more progressive than others, and ensuring that work is recognised as a part of this broader reform, I think is important, and that it doesn't get lost in the system. There's a concern that expressed from some quarters that by starting a new baseline with this legislation in respect of progress, that recognition is lost. Do you have a view on that?
I agree that some employers absolutely have achieved more in this space, and the recognition of that is really important. There are other ways in which they are recognised, both through the attraction of staff, but also through awards processes through WGEA and through other, the SAGE processes. I don't think that it would be lost to have them starting from a baseline, because each organisation, it's very difficult to come up with a uniform baseline, and so each organisation would have to take its steps according to where it is currently. And I think in some ways the benefit that it gains is from its employees, from its general reputation, and from its ability in the whole network of legislation and regulatory scheme for how employers are seen. So, for example, in positive duty as well. It also benefits. So it benefits in other ways by having already achieved or taken really concrete actions towards gender equality.
Okay. Thank you. That was a point that was made, I think, quite well by the Law Council previously, and I think they're values that not necessarily so intrinsic, but are looked at by people more broadly, and therefore have a value in that sense. Yeah. So thanks, Chair.
Senator Waters.
Thanks very much, Chair. Hello, Commissioner. Thanks for your time and for all the work
Hello,
you continue to do, and obviously standing on the shoulders of fantastic sex discrimination commissioners before you. I'm just getting a close look at the actual gender equality targets. Have you had a chance, I know you've got a lot on your plate, have you had a chance to look at the actual list of gender equality targets, which took some finding? They're in attachment A to the explanatory memorandum to the bill. And if so...
I haven't looked at them specifically, so if you want a comment, yeah, if you could run me through.
All right. Well, look, if you get a chance and you have a glance at them, in the next week or so, any feedback on whether you think they strike the right notes and would address the right causes of discrimination and inequality and the gender pay gap, that would be really, really helpful to the committee. Thank you. And we've already talked a little bit about the importance of intersectionality and everybody appreciating that the experience of an employee is even more complex when they've got intersectional areas of disadvantage. And I thought your submission outlined that nicely. Can you talk to us a little bit more about how you think collecting intersectional data would help transparency and, importantly, would help cultural change?
It's a part of if we don't know what's going on and we don't measure it, then we can't actually make that change. So unless we actually measure, for example, the take-up of flexible work conditions by culturally, racially marginalised women or by women with disability, then we're not going to know whether the policy itself is effective for that particular group of women. So to ensure that the policy or the framework is effective for those specific groups which make up the whole, then we need to really have that data. And we have a rich society, cultures, communities within Australia, and to ensure that our workplaces are responsive and inclusive of those workers, we need to have the data that actually enables us to measure how effective a policy is.
And do you think that the bill will enable that, or do you think it needs to be amended to achieve that?
At the moment, it's very much focused on gender and it doesn't disaggregate. So that's one of our recommendations, is that one of the ways in which an employer could meet their targets is to actually include specific under each of the GEIs to collect data around the experiences of the range of workers rather than gender as a group.
I see. We might raise that with WGEA and the PMO or the PM, whoever it is from government body that's coming on next. I suspect they might say that's beyond the scope of this Act, given the title of the Act, but we'll see. They're good suggestions. The other suggestion that I particularly liked in your submission was for these new obligations to apply not just to the 500 plus employers, but to the 100 plus employers that are the ones that also have to do the gender pay gap reporting. Makes no sense to me that you gather this data and then you're not obliged to do anything about fixing the problem you've identified. And so I'll ask them about what's policy rationale for, only addressing the tip of the iceberg. But can you explain to us why you think it's important that it's employers that have 100 plus employees that should have these new obligations added to them?
Yes. So the reason why we would argue for that is the reach. So at the moment, though, all employers of 100 plus employees have to do that reporting on gender pay gap. So in that way, they're already captured by the WGEA data gathering, and so therefore to extend it further is not a large extension, but it also would have the impact of increasing the number of employees. If it's only 500 and more, then it's only 1 in 4 employees, whereas it would increase substantially the number of employees who would then be covered by the protections and the employers who are having to meet these targets. So it's both the reach as well as the ease with which it could be done.
Okay. You don't happen to know the number of employee, like 1 in 4 for 500 plus. Do you have a number for what it would cover if it was 100 plus?
I think that's in the ACTU submission.
Okay, I'll look that up. Thank you. And I also liked your suggestion of employers needing to select rather than 3 targets, 4. Can you run us through the rationale for that suggestion?
The rationale really is around the slowness of change, and also that change doesn't always happen in one direction, as demonstrated by the gender pay gap having worsened in 44% of employers. So overall it's improved in the last 12 months, but for 44% of employers it's actually worsened. So it's recognising that gender equality requires action and requires commitment, and that it is a very slow process when we think about how long it would take to actually reach wage parity, let alone ensuring that we get women participating and being able to succeed in work at the same level as men. And so it's recognising the slowness of that change, and also that it doesn't always tend towards equality, and the importance of therefore driving that at a faster pace.
Thank you. And lastly, obviously you would have seen with the new administration taking office in the US, this pushback against diversity, equity and inclusion. Do you harbour any concerns that a similar sort of approach might take hold here? Are you hearing any rumblings of that? What's your advice on how, as a society, we should defend and be proud of our desire to overcome disadvantage in the workplace and everywhere?
I think one of the things that I have recognised since being in this position is that there is a level of bipartisanship around gender equality, and particularly dealing with domestic and family violence, for example. And I would hold on to that bipartisanship. We recognise how equality and gender equality particularly benefits everyone in our society, and that it isn't just one party politic that captures that or represents that there have been significant achievements across all governments over the last period of years, and that I would certainly encourage that continued approach.
Thank you. I was thinking more so of the business sector or other parts of the corporate world as opposed to the differing political parties, but I appreciate your perspective on that also. Are you hearing any pushback from business against these sort of what I consider to be positive initiatives to address inequality?
No, and I do a lot of consulting with and presentations to business through the Positive Duty implementation. And what I hear is a very strong commitment to ensuring that sexual harassment and other forms of unlawful conduct are eradicated from workplaces. And so from business, and particularly large businesses, there is a real commitment to that. I think there's sometimes a lack of understanding of how or the best way, or feeling concerned about legal obligations, but what I hear in my meetings with business are in fact a strong commitment, and that's across some very traditional workplaces, legal workplaces, as well as mining companies and construction companies. There's definitely a commitment to that.
Oh, well, that's very welcome news. Thank you, and appreciate your continued advocacy to keep them on that track. Thanks, Chair.
Thank you, Senator.
Questions.
Thank you. I will now move to our final panel for the day.
Thank you very much.
We have with us officers of the Office for Women and the Workplace Gender Equality Agency. Thank you and welcome for your attendance today. I understand you've received information on parliamentary privilege. I remind senators that the Senate's resolved that an officer of the Department of Commonwealth or State shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister, and that this resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about how they were adopted. Officers are also reminded that any claim that it would be contrary to the public interest to answer a question must be made by a minister and should be accompanied by a statement setting out the basis of the claim. Now I'd like to turn to those giving evidence this afternoon. I welcome you and I now invite you to please state your full names and capacity in which you appear.
Thank you, Senator. Megan Lay, First Assistant Secretary, Office for Women. Angela Hope, Assistant Secretary, Office for Women.
Mary Wooldridge, Chief Executive Officer of the Workplace Gender Equality Agency.
And good afternoon, Jeanette Dines, Chief Operating Officer at Workplace Gender Equality Agency.
Thank you. I now invite you to make opening statements and I'll invite the Office for Women and then Wijia.
Thank you. Thank you for the opportunity to appear before you as part of the inquiry into the Workplace Gender Equality Amendment Setting Gender Equality Targets Bill 2024. This bill responds to recommendation 3.1A of the review of the Workplace Gender Equality Act, which was commissioned in 2021 and delivered in 2022. 3.1A recommended that employers with 500 or more employees commit to, achieve and publicly report to the Workplace Gender Equality Agency on measurable, genuine targets to improve gender equality in their workplaces. The target scheme established in this bill has been designed largely based on the parameters set out in that recommendation, in addition to commissioned research and stakeholder consultations. This is a world-first scheme that aims to build and accelerate workplace gender equality. Studies from Australia and around the world have shown that there are significant gains to be made in achieving gender equality and broader diversity in workplaces, not just for individuals, but for companies, the economy and society more broadly. Here in Australia, the gender pay gap represents an estimated cost of $51.8 billion a year to the Australian economy. The target scheme outlined in the bill is focused on driving gender equality outcomes in workplaces and at the same time minimising regulatory burden on employers. The targets are directly linked back to the data points that employers already report annually to WGEA. This means that there is a strong evidentiary basis to assess an employer's baseline and their progress against their selected targets. It also means that employers are not required to do any additional reporting when it comes to WGEA on their progress. In terms of the split of responsibilities between these two bodies, the Office for Women is the lead on workplace gender equality policy in the Commonwealth, and WGEA is responsible for implementation and administration of the Act. Given WGEA's relationships with employers and other stakeholders and the data they collect and have deep knowledge of about employers across Australia, we work together to support the development of this bill. We've listened to the witnesses today and appreciate their engagement on the target scheme as well as the committee's engagement, and we are very happy to take any questions the committee may have.
Thank you. To WGEA.
Thanks very much, Chair, and it's wonderful to be able to contribute to the debate and the discussion in relation to this targets bill. And just to briefly add, the context has been that improvement on the gender pay gap's been slow and we've got to accelerate change. And the two key recommendations on this out of the review was that WGEA should publish gender pay gaps to enhance transparency, and that larger companies should be required to set and achieve targets. And the second aspect, of course, this will be the first time that the Act requires employers to actually take action in addition to their reporting mechanism. So it's a significant step in terms of enhancing responsibilities and expectations of the Parliament and the government to employers in the Australian context. We've obviously been the implementation of publishing gender pay gaps, and now we're at the point of, obviously the Parliament is at the point of considering this recommendation. And WGEA believes that this will be a catalyst for sustained improvement by larger employers and contributing to accelerating improvement on gender equality in Australian workplaces. And the reason is the evidence shows that targets work. They change behaviour, they increase accountability, and that progress happens at a faster pace. And it's been a very thoughtful process to get to the design and the operation of the scheme, including the menu. And it draws on the evidence that are, the evidence-based inputs and outcomes that progress gender equality. That's been the design feature in terms of the characteristics of the menu. And of course, it's been importantly informed by the work of Leonora Riz, who we've heard today, and also extensive consultation and input from the Global Institute for Women's Leadership. And the key elements are reducing that reporting burden. So we're limiting the burden that's placed on employers through the scheme and allowing and ensuring that the focus is on the work to improve gender equality in their workplaces. So the dynamic in terms of really, and it's been very reassuring to hear the witnesses today reinforce the reduction in the reporting burden, but that enables that time and effort then to be spent on the taking action. That there is flexibility for employers to choose, so that this bill meets employers where they're at in terms of their maturity. And also that the threshold is progress. And once again, it recognises that the process of setting, monitoring and working towards targets is absolutely fundamental to the achievement of the outcome. And so that progress and that work is critical. There was just one point I thought I might raise in response to listening to the witnesses today, just in terms of some of the numbers of the size of the scheme, because there's been some discussion in relation to the 500 plus employees. And just for the numbers for the committee's information is that while a quarter of employers are represented by the 500 or plus employees who report to WGEA, it actually represents 3/4 of employees that are covered in reporting to the scheme. And that's the nature of part of the decision making. And if the committee wants to go further, we can go into some more detail. But that idea that we can have a smaller number of employers who are required to do it, but the coverage of its impact is quite substantial, with 3/4 of employees being included. So I thought that might just be helpful context for the committee in their consideration. Thanks very much.
Thank you. I'll now invite my colleagues to ask questions. Senator Colbeck.
Thanks, Chair. One quick one, predictable, in relation to the issue of reasonable excuse that I've discussed with a number of people, and how that might be applied in a practical sense. It's an operational question as much as anything else, not in relation to any of the other provisions, but where targets have been set and established by the business, a process for a conversation around what might occur in an unforeseen circumstance of not being able to meet those targets, and the example of the way that the Victorian system works, noting that they don't actually set targets, but they do have objectives that they're looking to meet. But they do have a process by which they can have a conversation where something isn't being able to achieve through the way that their Act operates.
Thanks, Senator. I can address that question. And as you say, there has been quite a bit of discussion about it today. So the concept, I think you're already aware of, reasonable excuse already exists in the legislation, and it only arises in the context of the enforcement mechanism, if you like. So an employer who we believe is non-compliant is given an opportunity to offer a reasonable excuse, and it doesn't change their status of being non-compliant, but it does determine on whether the next step occurs, and that is that WGEA might exercise their discretion to name the employer. So we think that it's reasonably well understood at the moment, and it's no more difficult or no more complicated than what a reasonable person in all the circumstances of the employer's case would consider constituted a reasonable excuse. So the legislation is very similar to other regulatory contexts which deliberately don't define the meaning of reasonable excuse, so that the Parliament intends there to be flexibility. And when the courts have determined it, they've backed that up by saying it's an objective determination. All of the circumstances of the case, of the employer's case, should be considered. The one thing, and it has been touched on today, is that you would be looking for something outside of the employer's control. So in our compliance strategy, we don't list what is a reasonable excuse, but we do provide examples of what isn't. So we provide examples for that if the employer was busy during the reporting lodgement period, that wouldn't constitute ordinarily a reasonable excuse, or that there were changes to CEO or other key personnel. I think the fact that we are now looking at reasonable excuse operating in quite a few different contexts. For example, one is the employer didn't report, one is they didn't meet the notification and access requirements, which were mentioned earlier. One is that perhaps they didn't make progress against or demonstrate improvement against their targets, does support not inhibiting that flexibility and enabling an employer to come to us and say, this is why I haven't made progress. So acknowledging as well that because the legislative requirement, if the bill is passed, will be either achieve or make progress, there will be, what we would be looking for in the application is that something has moved from the baseline when the employer set the target.
I'm concerned by your reference in your response that they will still be non-compliant.
Yes,
and the concern then flows to the concern that there's no appeal mechanism to this process. It's basically you determine that they're non-compliant, which obviously has implications for them. I get that that's an incentive, but there's no process for a conversation as to, okay, and I acknowledge there's a reasonable excuse clause in there, but you're just saying they're non-compliant regardless, and so, but no recognition of the fact that a matter beyond their control is a cause for their non-compliance. So they just get tossed into the non-compliance column, and I suppose something would flow from that to me would be, okay, well, let's not be ambitious in what we're talking about, in what we're trying to achieve, which then again flows into other evidence that we've had, particularly say from the Human Rights Commission a moment ago, who expressed their severe frustration with the pace of change. It's almost a procedural fairness process where you just make a determination they're not. It's not as if they're not wanting to be making progress, but so in a numeric sense, they've missed something. As far as you're concerned, they're just not compliant. That has implications for their business, and how does that measure up in a procedural fairness sense in that case?
Yeah, really good question. Thank you. So the second, so WGEA's determination that perhaps there wasn't, or let's say, for example, we wrote to an employer and said, we believe you're non-compliant because you've failed to achieve or make progress against your 3 targets. We would then give that employer 14 days to come back and tell us, one, yes, you're right, it's not an error, I haven't filled something in incorrectly that's leading you to believe that. So then we offer them the 14 days to make the excuse. If the excuse is accepted for us, for WGEA, in terms of administering the legislation, that's the end of the matter. If we didn't think a reasonable excuse was made out, we then move into a second procedural fairness process where currently the CEO then determines whether the enforcement mechanism in the legislation, which is the naming, is applied. So the second discretion comes in, which adds on for the employer. And then the employer, if the CEO decides, so the CEO could decide then, okay, you are non-compliant, you didn't have a reasonable excuse, but I can see perhaps you're a first-time employer, you're a small employer, you haven't been non-compliant previously. So on this occasion, I'm just going to write back and encourage you and offer you assistance to become compliant. If the CEO decided that there wasn't a reasonable excuse, the CEO would then write and say, you haven't offered a reasonable excuse, so I'm considering naming you, and then giving the employer 28 days to make a representation as to why that should not occur. So that's how the legislative scheme is working with the 2 aspects of non-compliance.
Okay, so in a more fundamental sense, in your view, the where there's been discussion about some guidelines or some more something more definitive about what constitutes a reasonable excuse, you think that the utilisation of the terminology in its broader sense already provides enough definition for that term within the legislation?
Correct. I actually think that it works more in the favour of an individual employer that we consider every circumstance. So we don't have a rigid list of things that we think are great excuses. We don't fall into any sort of moral hazard that I think the Sex Discrimination Commissioner referenced, that you wouldn't want to just offer up a list of things that were a disincentive, but we do enable that full account. And in this context as well, I think it's useful to remember, because the cycle runs for 3 years, we will be getting an indication each year of how an employer is going. So there will be conversations that are possible before we even got to the 3rd year where an employer hadn't made any progress against the 3 targets or the number of targets selected. We think there would be a very small number of employers where we would get to the end of the cycle, nothing at all had moved from the baseline they selected, and WGEA hadn't been in there discussing and helping them. So really the only time when the failure to meet the targets or make any progress is probably going to be relevant is in the first requirement in the bill, which is to actually select the targets.
Okay. All right. Thanks, Chair.
Senator Waters.
Thanks, Chair. Hello, all. Thanks for your time, and thanks to the WGEA folk for doing brilliant work. Can I start off with some questions? I think this might be for Office of Women because they're just nitty-gritty questions about the operation of the bill. And forgive me if I should know the answers to these. do the employers have an obligation to consult with their staff when choosing which of the targets to nominate as the ones that they will then seek to make progress towards?
In the current wording of the legislation, the answer to that question is no. There is currently not a requirement for employers to consult with employees in relation to the targets that they set under the scheme. But there is obviously in the proposed menu of targets, there is one target, GL5, that does obviously is the target that employers could choose if they wanted to, I guess, consult with employees under various mechanisms.
Okay. Did anyone in the formulation process suggest that that might be a good idea to have employers at least consult with people affected by these changes on what they thought would be the most effective ones, or is that just an idea that didn't arise in the formulation process of the policy?
I might jump in on that, and this consultation has been happening over 3 years with many, so it's hard to say definitively either way. WGEA would certainly be providing guidance, and there's a lot of guidance that will sit around this whole scheme, both on the process of setting targets, doing your gender pay gap analysis, doing your action planning so you're in a position to do your target setting, and employee consultation is a fundamental part of that advice and engagement to get to that point to be able to set them. So in the context of certainly the guidance on how to go about this process, that's a very clear aspect and part of it.
Okay, so the guidance of how to do this process suggests that employers actually engage with their employees on what might be the targets that are selected to seek to meet.
That's right.
Yeah, I'm pleased to hear at least that. That's great, thank you. And can I also ask, does it have to be do they have to be different targets after the 3-year period has elapsed when you set your second lot of 3-year targets? Do they have to be different from the ones that you've chosen in the first 3 years? Or can they be the same?
Just to respond to that, the design has been that it can be the same, with the view that people can continue to work on issues. So if you've got a target to reduce your gender pay gap, we're very happy if the next, if there's a target, say, to reduce it 2 or 3%, and then the target for the next 3 years is to continue to do that. The target work might be on a composition area, for example, in relation to, professionals or, other non-manager categories to be more gender balanced. So the scheme acknowledges that momentum and progress can continue to happen and should continue to happen, and it gives that flexibility to employers to say, okay, we've reached where we want to get on that area for the target. We're going to set a new one, or we're going to continue on the journey and the work where we've identified the biggest hotspots are, and that's what the work we want to continue to do, and the targets we will continue to set.
That's right. We wouldn't want the scheme to inadvertently sort of discourage employers to kind of continue to, for example, work towards closing a gender pay gap out of necessity of setting a new target.
Yes.
And another
one, you also don't want them to avoid issues that might be the thorniest ones for them. So how would you balance that? Is that something that WGEA will have conversations with employers about?
Yeah, especially for the action ones, because if you've done an action target and put those in place, you can't, by definition, set it again because they're already established. So, you couldn't, for example, because the wording of the menu is very careful in relation to enhance, make progress, improve on. So there's one there, for example, if you don't have a employer-funded paid parental leave scheme, put one in place. Well, once you've done that, it's no longer an issue. So in many ways, the action targets, and there's quite a few choices there for good reason, but many of them will be a one-off. If you haven't done it, you'll do it. And so that will I suppose, over time, and this is a journey. It's not just a 3-year, process. This will be, 6, 9, lots of cycles going into the future, all going well. Is that it will start directing to those more numeric targets where continued progress is, fundamental shift and improvement in gender equality as well.
Yeah, thank you. And I can see that in each of the targets, there's a number of sub-targets. I don't know if that's the right terminology, but for example, in gender equality indicator 1, there's 4 sub-targets. Again, sorry if I'm being confusing because I don't know the right terminology to use. When you're selecting, if you're the employer and you're selecting one, are you selecting the sub-targets or the overall gender equality indicator number 1 and all of the sub-targets?
No, you're selecting, so there's 4 choices in terms of GEI 1. But even under let's say, increase the representation of the underrepresented gender in a manager category. There's actually 4 manager categories that sit underneath that. So while there's 19 targets, there are actually many more to choose from because you could choose it's one specific level. So the focus might be on your key management personnel. It might be on your other managers, which is your entry level, managerial level. So there is more choice under some of these targets because there will be some categories that sit underneath that. And the reason for that is to allow employers, once again, to identify where their areas of work and improvement need to be and allow them to target them specifically to have impact. And that will flow through. So if you improve your mix of other managers, that will obviously flow through to your overall manager representation and your gender pay gap ultimately.
Okay, thank you. I appreciate the rationale there, but I'm just trying to understand how big the task of selecting 3 is then. If you can select these extraordinarily detailed targets, is that all you've got to do? And you've got 3 years to do it. But can you maybe just explain for me, of the 3 that you need to select, I understand 1 has to be numeric and therefore 2 can be action, but at what kind of height are you selecting them? What is the task that you're then bound to make progress on?
So the task will be specific to the category that's selected, and each target is a little bit different. So just to give you some examples, if you're putting in place an employer-funded paid parental leave scheme, that is very clearly, that's the target. Under Gender Equality Indicator 1, which is really where, or let me give you an example of one we talk about, the target being to reduce your employer gender pay gap towards 0. You can choose that target as detailed in the menu currently to be your median or your average or your base salary or your total REM.
Oh, yeah.
And so you've actually got 4 choices within that target of what you work on. Some may be saying, well, my actual issue is in bonus and discretionary pay. I'm going to focus on total REM. The evidence from the UK shows that actually many employers actually started working on base salary because that was more tangible, and the work on bonuses has actually occurred at a later stage after the gender pay gap publishing transparency. So it's trying to reflect that in some of these targets, there are components of them, all of which are really valid targets to set, and all of which actually help them focus on the change that's needed and will improve gender equality.
Okay, just for clarity's sake, because the explanatory memorandum, which has attachment A that's got the targets in it, doesn't have any of those extremely granular levels of detail that you've just mentioned. And I feel like I want to see them before, we pass a bill that says these are what we're asking people to do. Is there somewhere I can find them? Because it's not in the EM as it stands. It's just got the GEIs and then it's got their like there's 4 under GEI 1, but there's not those extra categories that you mentioned. So where do I find those?
Megan, do you want to?
Yeah. So Senator, I think probably what is in the EM does sort of go to. So, for example, the example Ms. Woolridge was using just a moment ago around reducing the employer gender pay gap towards 0%, it does sort of break down in the attachment A to the EM. It does kind of break down if employers want to choose, an employer wants to choose median or average base salary or total remuneration, and then the kind of percentage point sort of reduction that then the employer would select. So that does, I guess, provide your sort of level of the level of disaggregation.
Okay, so those square brackets, that is the choice that they will make. Okay, excellent. Thank you.
Yeah.
Thank you. I appreciate that explanation. I understand that now. And I know I'm probably taking up too much time, so just one more question, please. A lot of the submitters have suggested that compliance in order to get government procurement, and some submitters suggested in order to be eligible to get government grants, that compliance with these targets should be required rather than just one consideration when procurement was being considered. Is that something that was, I thought that was the commitment the minister made, and of course the fine print says no, in fact that wasn't the commitment that was made, and I'm disheartened to see now that the commitment is just that it's one consideration. It's not in fact a bar to getting a government contract if you haven't met these obligations. At what point did that get so minor?
Yeah, I mean, it's the answer to that is in the, I guess, the construct of the procurement policies as they apply to the broader Procurement Connect policy scheme that's in place. So under the PG Act and the scheme around procurement principles, there, I guess, is a threshold that that needs to be met, and that threshold that needs to be met is around employers obviously providing their compliance certificate, and for procurement officers they must take that existence of a compliance certificate into consideration in terms of the decisions they make about the specific procurement that they are working on. So the words in procurement policies that apply that you must take into consideration that. So yes,
but not that you must reject someone if they don't have it. There's a difference there. Of course, you've got to consider it, fine. But if you're allowed to then ignore the absence of a certificate of compliance, well, it won't achieve the objective, or what I thought was the objective.
Yeah, so I mean, this is the sort of, I guess, long-standing compliance. This is the sort of long-standing, like the compliance framework doesn't sort of fundamentally change under the WGEA under this particular bill. What it does is, I guess, it changes the threshold for being considered compliant for large employers having to meet that target to be found compliant, which doesn't sort of currently exist. But in terms of how the WGEA, or the Workplace Gender Equality Act, interacts with the Commonwealth procurement connected policy, that's not changing. That's remaining consistent. And the target scheme, the way the target scheme element of the Act, if passed, will apply and will kind of interact with the procurement connected policies, will be consistent with how the rest of the Act interacts with procurement connected policies in the Commonwealth.
Thanks. I do understand all of that, but basically you've just got to show you've made reasonable progress over 3 years. And then if you haven't, that's not a barrier to getting a Commonwealth procurement contract, which I think is a really gross missed opportunity. But that's just my political view. So I'll stop now. Thank you. Thanks for your time.
I wouldn't say it's not a very hard barrier. I guess it's not a barrier that sort of excludes, but it does present a barrier. It's a key piece of information that must be considered by the procurement officer or by the community grants. Yeah.
Yes, but they can still give a Commonwealth contract, can't they? Without a certificate of compliance, they can.
Yes,
which is a shame.
Thank you, Senator Waters. I'd now like to ask, deepen those questions about certificates of compliance. So can I ask what that certificate might show? So I understand they've got 3 compliance requirements: baseline reporting, setting targets, meeting targets. Will that certificate show all 3 aspects?
I can answer that, Senator. So each target, when we assess compliance, will be looked at in its own right. So if you did fail to make progress against one target, but you had achieved the other 2, then that would not enable you to receive a certificate of non-compliance. And just referencing back before that, in that determination, if all 3 hadn't been achieved, we would still be asking an employer to offer an excuse as to why. We will look at the number of targets individually.
And can I ask how you will draw on the existing reporting to define the future targets under the Act and what they are and how they apply?
Can I just ask a piece of clarifying question? So was your question about future...
What the targets will be as a result of this Act, as a result of this legislation? I guess I'm a little bit unclear how set out they are or the extent to which my understanding is that you can still consult about what those targets will be.
Yeah,
what you're reporting against,
Yeah, so I think the targets that are currently in the menu on the explanatory memorandum are the targets that we are proposing to be for this cycle of the targets scheme. So if I'm interpreting your question right,
do we need new legislation to change them, or are they defined? Yeah.
Okay. And can you just... the targets menu will be, that is currently in the explanatory memorandum, will need to go into a delegated instrument. So the process that we are going through now is drafting up the delegated instrument, which will include the targets menu in it, and it'll also include the rules to which employers will need to select their targets from that menu, how many targets they need to select, what categories they might need to be in, are the other things that will appear in the rules.
Can I just add? Oh, sorry, Megan, you go.
Sorry, thanks, Mary. The targets that are attached to the explanatory memorandum, they are based on questions that WGEA currently asks as part of their reporting in WGEA's existing questionnaire, which sort of goes to that point around sort of it's not going to increase reporting burden for employers. I think in terms of your question around what about future targets, if future targets require WGEA to ask more questions, or different questions, will that require a legislative change? Ms Woodbridge and Ms Steins can probably provide more detail, but my guess would be it depends on the nature of the questions and whether or not they're currently covered by the Act and the gender equality indicators under the Act, or if they require a kind of further refinement of the gender equality indicators. But I might pass to WGEA colleagues to clarify if I'm telling fibs.
Yeah.
Thank
you.
I
guess just to add to that. Sorry, I'll let Mary go first.
just going to say, said what I was going to say as well there in relation to what's critical, and there's been a lot of suggestions in your submissions about a whole range of things that may have targets. But if companies are not currently reporting on them, then we don't have a baseline and we don't have the mechanism to put this scheme into place, consistent with what's in the legislation if it's, passed in this term of Parliament. So, there's always opportunities to discuss the evolution of reporting to WGEA, and that's something that happens regularly. But our view is that the menu represents the best evidence-based inputs and outcomes that can be drawn from existing reporting that we know will progress gender equality. So it's been, shaped and consulted on and thought through very carefully in that regard.
Yes, I am supportive of those. How that has been established in this bill. You might have heard my earlier questions about exemptions to the Sex Discrimination Act. How do you see, because the targets in many cases relate to provisions of the Sex Discrimination Act, how do you see the relationship between an employer that may rely on that exemption and their reporting requirements under these targets?
Yeah, Ms. Woodridge might be able to address this one.
Actually, Jeanette, did you want to comment? You've thought through some of this.
Yeah, I think that as a matter of practice, it would be very unlikely that an employer who was seeking to rely on an exemption would select a target around it because they wouldn't be motivated to take that action. And we haven't assessed the...
Sorry, just so that I can understand the answer, can you direct me in the EM to where that list of targets is and which ones do relate back to the provisions of the Sex Discrimination Act?
So it's toward the a copy of the target. What could be the target menu is towards the end of the EM, as I recall.
Yeah.
Yes.
And which ones of those relate to provisions of the Sex Discrimination Act?
Senator, is this particularly in relation to the positive duty requirements under the Sex Discrimination Act or more broadly?
Well, both. I need to know the answer to that as well. Yeah.
I think so. I think just to kind of start off with, GEI 6, obviously, the sexual harassment on the grounds of sex or discrimination is the GEI, obviously, that relates to positive duty.
Yes.
So obviously there are a raft of policies or strategies included there. So obviously positive duty does require organisations to take proactive kind of actions to prevent kind of discrimination and harm in the workplace.
Yeah.
And those actions there that are included in GEI 6 are framed in a practical way to help organisations meet their positive obligations or positive duty obligations under the Act. So I think that's the rationale for having those particular indicators or targets there framed the way they are. So that answers part of your question. I don't know whether Jeanette had anything further to add on that. But I think that's the positive kind of duty element. I think is the big piece that we're looking at here in terms of GEI
Okay,
6.
GEI 4, yeah.
6.
6, sorry, yeah.
6, which is the last of the list in the menu.
And it's certainly correct to say that some of what you might do to meet your positive duty to take proactive and meaningful action to prevent unlawful conduct could be one of the actions that we have offered up in the target menu, but we by no means would see those as exhaustive, although we would see them from a GEAR's perspective as representing current best practice as things that will be impactful under that GEI and therefore contribute to improved workplace gender equality.
Yeah, yeah. So I just want to, if you're, for example, you've selected improved working, flexible work offering for employees, and on paper you are definitely progressing. So you might be a religious affiliated school, and you report that yes, that's what you're going to pick, and you are improving that offering, but to then deprive someone who might have been pregnant out of wedlock for that offering, how does that, if someone applies exemptions, I guess, to their reporting, how would you expect that to be reflected, if at all?
I think that's a really good example, Senator, of a conversation we had about this previously, in that the WGEA regulatory framework isn't about what happened to an individual. It is about the kind of systemic framework and the ideal policy settings. So we couldn't rule out that your example could come to pass in a workplace, and because we look at the system level, it wouldn't necessarily be detected under the reporting, and you might meet a target but still have a representation from an employee that had occurred.
And of course that could occur with or without the target, and with or without an exemption to the Sex Discrimination Act. I guess what I am keen to understand is, there might be an outlier where, yes, an organisation is reporting that they're doing the right thing and progressing in the right direction. And if someone were to take a case to the Human Rights Commission, unless there was just a reasonable misunderstanding or a capacity to negotiate, you would not expect an employer to rely on an exemption. Are we able to distinguish between employers that might rely on an exemption and those that won't? I understand we won't necessarily see outlying cases of discrimination, but surely we should be able to see if there are exceptions to when an organisation says, yes, they are committed to meeting this target. If there are any caveats, for example, to that would fall within the Sex Discrimination Act as intended.
I think it would be very difficult because it's not a data point that we collect, despite there is a reference, as I know in the Workplace Gender Equality Act to compliance with the Sex Discrimination Act, but we don't affirmatively ask employers for any information around that.
I guess that's therefore a policy question as to whether identification as a religious organisation and as whether you would seek to use those exemptions becomes a policy question about whether that information should be collected as part of your mandate or not. That would be correct.
Correct.
That's right.
Thank you. That was a really terrific day of evidence, and I really want to thank the Office for Women and WGEA for the amazing work you've done in progressing this. I'm hopeful of it passing, and, very committed to the difference that it will make in delivering gender equality in Australia's workplaces. Did I have any last questions from my colleagues?
Maybe just quickly for WGEA, and very happy for you to take it on notice. I noted in your sub you said that WGEA would support employers with target setting. Just keen to understand in what fashion that will be. So if there's anything you've got already written that you can just send to us to explain how you'll help them choose and what other info you might provide, that would be useful for us. Thank you.
And the very quick answer, Senator, is there will be a guide that sits alongside the menu, which we're drafting in the hope that this passes the Parliament, with all the guidance about the evidence base in relation to the targets and considerations on its implementation. We also have the series of masterclasses. So, analysing your gender pay gap, doing your action planning, setting your targets, and that's the journey that we take employers through should they wish to participate. And we've had over 1,000 employers already participate in our analysing the gender pay gap masterclasses as part of that process, and there's other classes as well. So it'll be a combination of written guidance and face-to-face masterclass type settings, and always the capacity to do direct advisory, to work one-on-one with them to solve some of the harder and more intractable challenges, and to think through how employers might be able to make change.
And just quickly, is that guidance document the one that will include the suggestion that they consult with staff in selecting which targets? Great. Thank you. Thanks, Chair.
Thank you very much to all of our witnesses today. We look forward to reporting as a committee, and I'd like to thank everyone for their participation. I think we've got a very tight turnaround for questions on notice, but I think the witnesses that took those questions know that. So thank you very much to all our witnesses and everyone who's submitted submissions to the inquiry. With that, I will now adjourn the hearing. Thank you.